Good morning, everyone. Buongiorno a tutti, and thank you for being here with us after so long. I start with introducing you our director of the Department of Law, Professor Andrea Sassi, che vi inviterà poi a un indirizzo di saluto. Prego, Andrea.
Grazie. Grazie a tutti per essere qua. Io porto i saluti anche del magnifico rettore dell'Università che avrebbe voluto essere qui. Il nostro magnifico rettore è molto sensibile alle iniziative che sono di livello internazionale come questa, per cui purtroppo ha avuto un impegno improvviso e non può essere qui oggi, però mi ha pregato di portare i saluti suoi personali e di tutto l'Ateneo. A mia volta io ringrazio in maniera particolare la professoressa Lanciotti, il professor Bezzani, tutti coloro che hanno partecipato a questo progetto, tanti colleghi, vedo la professoressa Fonti, il professor Cociani, che hanno partecipato a questo importante progetto. Queste iniziative di internazionalizzazione sono fondamentali per il nostro Dipartimento, che appunto si vuole aprire in maniera sempre più importante al mondo e ai problemi che ormai sono problemi globali, come vediamo purtroppo in questi momenti così drammatici che ci hanno portato la guerra molto, molto vicino a noi. I problemi finanziari di cui si occupa appunto il progetto coordinato dalla professoressa Lanciotti sono ormai fondamentali in tutte le branche del diritto, quindi veramente sono molto contento di questa iniziativa e ringrazio tutti coloro che hanno contribuito a portarla avanti. Mi scuso se non potrò seguire tutti i lavori, perché a breve ho lezione, però spero di tornare poi per la seconda lezione e per la seconda sessione e magari anche non da solo. Quindi auguro a tutti buon lavoro e grazie per essere qui.
Grazie. Grazie al professor Sassi. Thank you, professor. So now we start this conference, which will illustrate the laws and practice applicable in the field of restorative justice, mediation, and protection of EU financial interests. Actually, the topic of this conference develops the research work that has been carried out within the DRUMP project. The DRUMP project, where the acronym DRUMP stands for Diversion, Restorative, and Mediation Procedures in PIF Crimes, is a European project which was funded by the European Commission's Directorate General for European Anti-Fraud Office within the Hercules III program, Legal Training and Studies 2020. Notably, the Hercules programs found action aiming to prevent and combat fraud, corruption, and other illegal activities affecting the EU financial interest. I see here Professor Carloni with us, who is the scientific coordinator of another project funded by the same European action. And I thank you for being here with us. Within the framework of the program, the mission of the DRUMP has been to gather data and analyze legislations applicable to dispute resolutions in cases of fraud offenses, in particular of fraud affecting the financial interests of the European Union, and thus falling within the competence of the newly established European Public Prosecutor's Office, the EPPO. The idea to carry out such study took the start in March 2020. That was an unfortunate time with all the restrictions due to the sanitary emergency. And so with a group of professors from this department, we had the idea of making this study starting from the consideration that the European regulation on the establishment of EPPO in Article 40 makes a specific reference to simplified prosecution procedures. Those simplified procedures are taken into account by the European delegated prosecutor, who may propose to the competent permanent chamber to apply such procedures, provided that this is in accordance with the conditions provided for in national law. This is according to Regulation 2017-1939. So we thought that it could be an interesting strategy to identify those simplified procedures and examine their possible scope of application within the existing landscape of judicial cooperation in criminal matters. So a scientific committee was set up within the law department, the members of which are professors from different areas of legal expertise. Professor Cocciani, tax law, Professor Fonti, who's here before me, a criminal procedure, as well as Professor Montagna, Professor Sartarelli, criminal law, and Professor Valentini, criminal law and European criminal law, Professor Vezzani, our speaker today, EU law, and myself. Then, through our contacts, we worked to create a network of academics and experts based throughout Europe, from Austria to Greece, from Belgium to the Balkans, from the Baltic to Austria, everywhere in Europe. I mean, not everywhere, but in a large part of the European countries. Actually, the whole research work wouldn't have been possible without the cooperation of this fantastic transnational legal network of jurists from different European countries. Some of them are present here today, while others could not come to Perugia in person, but are attending online, and I welcome them as well. And let me express, on behalf of the DRUMP Scientific Committee and of the whole Department of Law of Perugia, our deepest gratitude to all of you that are part in the DRUMP research project. We are immensely thankful to each and all of you and greatly appreciate what you have done and are doing, for you've made it possible for the DRUMP project to be successful. And considering the different background of the participants to this conference, we've planned this conference to be a place of confluence where professionals can meet and exchange ideas and expertise. The distinguished speakers who are taking part to the conference have been grouped in sessions following a merely geographical criterion. To begin with, the first three speakers of this panel will examine the EU legal framework and the origins of the EPPO. Then, in the next panels, national experts will present judicial and practical issues on alternative dispute resolution from different perspectives. I remind you that every presentation can last a maximum of 20 minutes. I know it's not a very large amount of time to tackle all the issues, but we have a rather tight schedule, as you can tell from the program. However, the outcomes of this 2 days meeting will be published on a freely accessible digital book printed by the University of Perugia in the summer. And I do hope that such a publication will be beneficial for the relevant institutions, including the EPPO and OLAF institutions. Also considering that, as far as I know, there is still no such comprehensive study on the matter. Also, we have created an online database which is still under construction with the aim of mapping the legislative solutions adopted at the national level by the different European states. States participating in the EPPO enhanced cooperation, as well as EU candidate countries and member states that have not yet entered the EPPO cooperation. I thank you all. The website is drump.eu. Make sure you don't put drump.net, because that is another database, but of biochemical amino acids, antipeptides, or something like that. In fact, they are also creating a data repository, but on a different subject matter. So on the drump.eu website, we have already uploaded, our webmaster already uploaded some documents. There is a map with all the European countries, and if you click on the map, you will see the national reports and a brief summary of the relevant pieces of legislation applicable in each state. It is still under construction. We will, I hope the webmaster wakes up and uploads the remaining documents. And we thought that this is a good way for a dissemination of what we've done so far and we are doing. Finally, the outcomes of the conference will be published in the conference proceedings that is expected to be edited by this summer. So I thank you once again for being here, and I now give the floor to Dr. Francesco De Angelis, who will tell us something more about the protecting protection of the financial interests of the EU, which has been a long journey because the idea of the creation of the EPPO office is apparently one of the most contested EU criminal law topics in recent years. Dr. De Angelis is Honorary Director General of the European Commission. He's an Italian lawyer, and he's been the director of the DG for the financial control of European Commission, then worked as director of the Directorate General for European External Action Service, dealing with the implementation of the rule of law and democracy in non-EU countries. In his capacity as a director, he is one of the promoters of the Corpus Juris and also the promoter of the Association of the European Criminal Law Associations dealing with financial crimes. Grazie a Francesco De Angelis per essere qui. Sì, prego. You have the floor.
Grazie professoressa. I will try. I always three versions of a speech when I ask to intervene in a conference: the red one, the yellow one, and the green one. So, of course, the red one is the shortest version. I will try to stick to the short version. Ciao ragazzi, soprattutto a voi. Allora, noi abbiamo per il Procuratore Europeo, il Ministero Pubblico Europeo, è il primo organo investigativo a livello europeo. Quindi è un'innovazione incredibile. Alcuni anni fa mai sarebbe pensato avremmo realizzare questo obiettivo, ma è stato un lungo percorso e io sono poi uno dei protagonisti di questo percorso di 30 anni quasi, per cui ve lo racconto un po' rapidamente. Se potete anche interrompermi e dire non ho capito niente, stai facendo confusione. Oh, sorry, I have to speak English. Yes. Well, as I said, it was a long parcours. It was in the 90s when I was working in the Financial Control Department as like Ragioneria Generale dello Stato. I was responsible for controlling European funds in the area specifically of agricultural fund. I noticed a lot of difficulties to implement the community rules, community provision at the level of the management, control, and investigative power. It means that specifically I started to initiate how the judiciary, how the judges, public prosecutor were involved in the fight against fraud. Well, it must say that it became apparent and the anti-fraud case dispensable were considered not a priority for national public prosecutor. The reason was the complexity of legislation, technical assistance from national department responsible for management was lacking, difficulties in cooperating with their counterpart in other member states when there were international fraud. And Brussels, I don't know now, is considered something far away from our mind, you know, and European money, which is taxpayer money, European national taxpayer money, was considered res nullius and not res omnium. This was the situation. So I started to say they cannot go on as a responsible of the good management of European funds. And so I organized a huge seminar with 300 people in the 89 with all the stakeholders involved at the national European level, judiciary, controls, the judges, European level, the Court of Justice, lawyer, public manager, and so on. And we had a big success. It was in '89. You were not, of course, not born. And the question was, idea, what do we do? Well, we started with an Italian lawyer, Vania Cirese, to create association for protection of the European community fund at that time, which means criminal law, of course. And the first one was in the Palazzaccio in Rome, where the seats of the Cour de Cassation, Corte di Cassazione. And and we created 36 associations in the member state in the applicant country already. And then we create a kind of review, which was AGON, fight against fraud, the Greek term to AGON, and which now has been replaced by a more scientific one, which is EUCRIM, led by Max Planck Institute in Japan. Why we wanted to go further with the legislation in criminal law. I thought we should have the maximum we could go. So create a European legal space where a judge from Turin would go freely to Lyon to cooperate with his colleague without any frontier, without any border. As we were in Italy, he would go to Naples or Rome, etc. And I put together the most important criminal lawyer in Europe, and I put them together and told them, now you have to produce something which is revolutionary. Of course, it was not easy. They started to talk about typical transfer of procedure, judicial assistance, the old category of criminal cooperation which was established in the Council of Europe. And I said, no, you didn't understand anything. I will not pay you if you don't make more effort and try to produce a European legal area. I even said to the member, say, I will not pay you if you don't produce what I am in mind. It was not easy to let them understand. And since things didn't go very well, I say, now, you have near Bruxelles, Chateau Vieux-Lac is a beautiful place. You stay there 3 days and come up with something reasonable, something revolutionary, something which we can launch around Europe. And well, the first morning I went there and they said, well, we have invented the European Public Prosecutor in Brussels. Say, well, but this is a new carrozzone, I know in Brussels. They will say, a new body, which is a heavy body. We have already so many European bodies. I say, well, think again one night more and let me know. So they came back, Madame de Masmarty, who was then, there was a French lawyer, the most famous French lawyer in France, member of Collège d'Europe. She died like a month ago, but she was the, let's say, protagonist of criminal law in France, in Europe. So we can remind. So he said, well, we have thought about European delegated prosecutor, which will stay in the member states. This is okay. I really accept that. If the structure in Brussels was a light one, which would coordinate, but the bulk of the competence of the investigation will lie with the European delegated prosecutor. And the same time, we elaborate 35 articles. The first, of course, we had the traditional distinction between the general part of criminal law and specific part of criminal law with 8 articles, and then there were 18 articles, and the rest, till 35, was about European public prosecution. The question about that was that there were already some progress in terms of European criminal law, and the Charter of Justice has established the principle of assimilation, which means that the national management control authority have to give the same importance to European fund that they give to European national law, but which means that remain the difference because the legislation different member states were different. So I pushed hard for unification. I want articles which apply in all member states, and we had 18, and this is the first version, the Corpus Juris. You can give a look if you want. The procedural part, of course, the discussion were very, very intense. It was necessary to have a great capacity of imagination to design instruments suitable to create a single legal space, allowing the public ministry responsible for investigation to move freely throughout Europe. The category of conventional intergovernmental cooperation had to be abandoned. The proposal strike the balance between the idea of creation of new European authority and the appointment of a national authority, as I said. And the most innovative proposal was that for the need of search, prosecution, judgment, and execution of conviction, all the territories of the member state of the Union constitute a single judicial space. This was a revolution, of course. The second innovative element is, I said, the proposal to create the European Public Prosecutor Office, which is independent from national authorities as well as European bodies and has a jurisdiction over the whole of Europe. It was to consist in a large structure where the bulk of activity will be carried out by itinerant prosecutor. The delegated European prosecutor appointed by each member state among its own national prosecutor, and the European prosecutor is intended to move from one member state to another, while European public prosecutor based in Brussels would coordinate the investigation. It was, and the Corpus Juris, you know why we call the Corpus Juris? You remember Corpus Juris Justiniane, of course. And then I had a phone call in August with when we finished the study with Professor de Malmarty. She called me and said, we are going to name our study. Well, mini code, you know, containing disposal for, etc., protection financial interests, or provision to protect. Well, we were not satisfied, and she said, I will call you in 2 days. And she called me again, say, I found what? Corpus Juris. Well, Corpus Juris remind Justiniane's corpus is a very famous one, which is inspired also codification and he said, well, it's enough ambitious. Okay, we will call Corpus Juris portant disposition pénale pour la protection des intérêts familiaux. Alors, the Corpus Juris is a synthesis between inquisitory tradition and adversarial tradition, which is in the common law area, combines the element of monopoly of the public authority for investigation and prosecution, typical of executory tradition, and strengthening of judicial guarantee and the inherent to the adversarial model. We had also invented, proposed to invent a European preliminary chamber, like it's a formula inspired by the Statute of International Criminal Courts, authorizing the acts that may infringe on the individual freedom of witness and accused control. Which the proposal which concerned the preparatory phase become all the more interesting when one considers that with regard to prejudgment phase, that greatest disparity between national legal orders have always been noted. Now, we had this test. I sent different ambassadors all around Europe, also Maria Mercedes, Avvocato Maria Mercedes here, to disseminate, you know, like the Evangile, the Corpus Juris Nouvelle, the Corpus Juris proposal. And so there were a lot of discussion everywhere. And we presented it in Latin America, we presented in China, I presented, and also the applicant countries, the lawyer, they were inspired by the Corpus Juris in order to introduce reform for joining the European Union. So it serves as a legal base, it's a material for discussion. And modestly, I was approached by some professors say, finally, we have something different to tell to the student, apart from our traditional category of national law. So there was a really movement, but not everybody was let's say, in agreement. Following the remarks by many European criminals claim that Corpus Juris proposal will require, pay attention to that, very deep reform of the national constitution, penal codes and codes of criminal procedure, as well as rules related to judicial organization. A new study was launched by the Commission with the support of the European Parliament, no follow-up of the Corpus Juris, in terms of need for its implementation, feasibility, and recommendation to achieve, in accordance with the treaty, the objective and effective deterrent proportionate protection of your financial interests. This proposal was discussed around Europe with, let's say, at least 30, 40 lawyer academics around Europe. And we have a new version. We have the new version. This is this one, the implementation of Corpus Juris, second version. But you have my name, yes, it's more important. Scusate. Well, and there are 4 volumes of this, because we had the national rapporteur and horizontal rapporteur for horizontal topics involving different member states. Well, this is, again, the debates about the expert conference in the media and the political circle. Great attention has been paid to the proposal contained in the next text within member state European. The Corpus Juris has certainly fulfilled one function: to carry out a public debate on the role of criminal law and criminal procedural law in European integration. What are the European interests deserving of criminal protection, and how can this protection be organized so that the effectiveness of criminal protection is guaranteed in the European area? And this is, look at the, listen to this. It is necessary to adopt a project that is so upsetting national tradition and seems to run counter to a modern policy of prevention and decriminalization. Is Corpus Juris feasible, knowing the diversity of criminal and procedural law system, making it possible to harmonize, let alone unify it? The configuration of the European Public Prosecutor Office have been a subject of intense debate, as I said, for several years in the European Parliament, in member state, at level national parliament, representative government, universities. It's attracted great interest from academic Latin America, and I said in China, researchers from Central and East European accession country translated to their language and use it to promote the reform before they joined the European Union. Now, this was, but the Commission, notwithstanding the critics, went on, and we had the Green Book, in 2001, elaborated by Olaf, Office of Lutte Anti-Fraud, which was insisting on European prosecutor, the creation of European prosecutor, but notice that the Corpus Juris had proposed a high level or harmonized on material criminal law. It considered that harmonizing must be proportionate to the specific objective of protecting union finance. Thus, it restricts debate to minimum requirements for the European public prosecutor. It means that Olaf and the Commission, in the Green Book, they accepted, let's say, they put forward the idea of creation of European public prosecutor, but they didn't put forward the idea of European legal space in terms of creating a criminal code and the European procedural code applying to, of course, only to the European public prosecutor. The way the final decision, I say that because, well, okay, no. After the concept of European prosecutor in the Treaty of Nice was rejected, in the reform of 2007, the Lisbon Treaty provided a legal basis, which Article 86, resulting from the European public prosecutor, this article provides the possibility for a group of at least 9 members enhanced cooperation to apply and to adopt the European public procedure. And so the Commission, obstant the controversial debate around Europe, we were also in the House of Lords in England, Madame de Masmarty and Professor Spencer, to discuss about select committee, about devo finire? No, allora, io finisco dicendo che nonostante questo, poi dopo dice, c'è il professore, scusi, il Parlamento e la Commissione mandò avanti le cose, però ci furono molte critiche nei parlamenti nazionali, i cosiddetti yellow card, concernente la problematica della sussidiarietà e della proporzionalità, e quindi non tutti gli stati hanno aderito, all'inizio erano addirittura 12, poi 14, poi sono aumentati, e adesso abbiamo 22 stati, credo, e evidentemente gli inglesi non avevano, gli irlandesi e i danesi sono sempre stati un po' al di là del diritto penale europeo. La Svezia esita e forse ci entra, poi abbiamo 2 stati che per definizione hanno dei governi un po' dittatoriali, diciamo così, alla svelta, l'Ungheria e la Polonia, quindi noi vediamo un po'. Allora, io volevo dire che il pubblico ministero com'è, nonostante, se leggete come si chiama, il website del pubblico ministero, vedete dichiarazioni trionfaliste sui risultati raggiunti, però a mio avviso è necessario allargare le competenze. Una delle competenze più interessanti è quella environment law. Excuse me for the other, but well, I was talking Italian, I suppose.
It's a bilingual concept.
Okay. I think that environment, which is a real European community, let's say all community sector should be, let's say, should fall under the competence European. I developed this in my... Sì, no, allora voglio dire una cosa, ragazzi, questi professori mi sai... noi abbiamo, conclude per 2 minuti, voi avete cominciato col diritto nazionale, vero? Il problema in Italia, sa qual è che contrariamente alle altre discipline scientifiche, eccetera, il diritto negli Stati membri corrisponde a una visione strettamente nazionale. Cominciamo sempre col diritto nazionale, il diritto del lavoro, il diritto civile, eccetera, eccetera. E il diritto europeo e il diritto transnazionale è relegato a dei convegni o delle azioni specifiche. Per cui gli studenti credono che la scienza giuridica, cioè, contrariamente a altri settori, in Europa abbiamo tante scienze quanti sono gli ordinamenti giuridici. Praticamente la scienza giuridica si è sviluppata attorno alla legge positiva, agli ordinamenti positivi negli Stati membri. Per cui poi, per far parlare un italiano con un giudice, con un giurista francese, inglese, tedesco, abbiamo grosse difficoltà perché ognuno pensa essere il vero. Per cui io sono del parere che noi dovremmo, posso sviluppare di più però, lo dico in italiano perché soprattutto agli italiani, che dovremmo sviluppare un curriculum in cui i primi 2 anni è dedicato a quello che unisce l'Europa, che è dovuto al ius comune, al diritto comune, che è la combinazione di diritto canonico e diritto umano, al diritto che si è sviluppato tramite le corti di giustizia europee, Strasburgo e Lussemburgo, e a tutta la legislazione positiva che è stata creata. Quindi io direi che dovremmo creare un curriculum studiorum che inizi con quello che unisce i futuri giuristi in Europa, in modo che poi quando si incontrano parlano lo stesso linguaggio e non linguaggi diversi. E poi nello stesso tempo si crea quella méfiance, il mio diritto, per carità, quando ascolti i professori che il loro diritto nazionale, quello che dà più le garanzie giuridiche, le più le garanzie costituzionali, diritti della persona, ma delle stronzate, scusate. Abbiamo 2 corti che sono come dei cani di guardia, che ci sorvegliano, che ci controllano, che ci minacciano, che ci danno indicativi. Non è possibile questo. Quindi io direi che invece di perdere tempo e di perdere tempo di cominciare con questa visione ristretta del diritto, allora io dico questo: it could be easier to establish European culture based on the conscience of lawyer if studies begin in the first and second years with the transnational and European subject. Young lawyer would first understand what is common across Europe and then continue with the study of the peculiarities of national law. Students will thus become aware of the European legal culture developed over the century as the result of reciprocal influence. Possiamo parlare e farvi un seminario su questo, ma il messaggio soprattutto ai professori. Grazie, scusate.
Thank you very much for Francesco De Angelis for his comments on the long-standing project of creating a comprehensive EU anti-fraud regime, and for giving us an account of the debate which lasted for almost 3 decades. We would like that the EPPO could represent something of a jewel in the crowd, but we gathered that this is something yet to come. Maybe broadening the EPPO competences would be the way, and he also recommended us to give less importance to the national dimension, and that now has a dominant place to the detriment of transnational law and EU law. But I must say that at least in the Dipartimento di Giurisprudenza, our students do study international and EU law in the first 3 years of their career. So transnational and international law has a place in their formation.
Excuse me to interrupt, but this is not what you need. What we need is a curriculum. A curriculum was established on basis we have in common in Europe on the basis of long tradition. If you read Professor grossi, which is common law, the traditional jus commune, is very interesting. There are many professors in America. Why is America? Because America, I mean, there are 50 states which have different legislation, even in criminal law, but they study on the basis of the same curriculum. So of this common law, so that it's easier for them to talk to each other. It's not a question of language, English or the other language. It's a question of mentality, creating mentality.
We understand that. One announcement, there is a Wi-Fi for the room, for those of you who want to connect. There are papers here with the username and password. The password is Trump 2022. Username is, no, I don't read it, RL. It has been circulated, very well. So now I will give the floor to our next speaker. We are honored to have here with us il dottore Lorenzo Salazar, sostituto procuratore generale della Procura Generale presso la Corte d'Appello di Napoli, Deputy Prosecutor General to the Court of Appeals of Naples, and also chair of the OECD Working Group. Dottor Salazar is online, può aprire il collegamento, eccolo, grazie. He is online. He, before working as deputy prosecutor, he has worked for over 10 years in Brussels as a counselor to the Italian permanent representation to the European Union dealing with judicial cooperation, and then as a member of the private cabinet of the commissioner responsible for justice, liberty and security. After that, he was appointed in Rome director of the Office of Legislative Internal Affairs in criminal matters of the Italian Ministry of Justice. Welcome, Dr. Salazar. He will tell us about non-trial resolutions, soluzioni alternative al dibattimento nei negoziati EPPO e OCSE. Dr. Salazar, thank you once again for being with us. You have the floor.
Buongiorno a tutti, buongiorno professoressa, ciao Francesco. First of all, I prepare my presentation in Italian. May I speak in Italian or should I switch to English?
It is up to you.
Allora, mantengo allora l'italiano, visto che ci rivolgiamo, poi mi sembra, soprattutto agli studenti dell'università. 20 minuti per parlarvi di quanto è accaduto nel negoziato sulla Procura Europea in materia appunto di transazioni e soprattutto anche presentarvi l'esperienza accumulata nella sede del gruppo di lavoro sulla corruzione internazionale dell'OCSE, che a mio avviso presenta una serie di spunti interessanti anche sotto il profilo europeo. Ciò che va sottolineato innanzitutto è che nel corso del negoziato, Francesco ha raccontato molto bene come gli è costume quanto è accaduto prima, nel 2013 è iniziato un lungo negoziato su questa proposta di regolamento sulla Procura Europea che si è conclusa solo nel 2017 con 4 anni di lavori, anche nel corso della presidenza italiana del 2014, quando ho avuto l'onore di presiedere il gruppo di lavoro. E proprio in questa occasione abbiamo assistito alla modifica di quella che era la proposta iniziale della Commissione Europea in materia di transazioni di concordati. La proposta iniziale della Commissione Europea prevedeva nell'articolo 29 quello che si chiamava un compromesso, vale a dire un'armonizzazione delle procedure nazionali in materia di transazioni, di accordi, di concordati, chiamatele come volete, ma quello che è importante sottolineare è che la proposta iniziale della Commissione era una proposta di armonizzazione. Si prevedeva che appunto la Procura Europea potesse proporre all'indagato una sanzione pecuniaria forfettaria il cui pagamento avrebbe comportato l'archiviazione definitiva del caso. E questa archiviazione, sempre nella proposta iniziale della Commissione, non prevedeva alcuna possibilità di controllo giurisdizionale, quindi era tutto nelle mani della Procura Europea. Questa proposta iniziale della Commissione è stata completamente modificata nel corso del negoziato, in quanto il prodotto finale, il regolamento del 2017, prevede una non armonizzazione delle regole in materia di transazione. Già il considerando 82 del testo finale parla di appunto procedure di concordato laddove tali procedure esistano. In sostanza non si è armonizzato, ma è possibile pervenire a procedure di concordato soltanto nei casi in cui queste procedure già esistano a livello nazionale e soltanto in quei casi queste procedure saranno previste. E questo lo trovate appunto espresso nel testo del regolamento, e in cui si dice che tutte queste procedure devono essere esercitate conformemente alle condizioni previste dal diritto nazionale. Questo è l'articolo 40. Se il diritto nazionale applicabile prevede procedure semplificate di concordato. Quindi questo è il passaggio fondamentale, e tutto viene esercitato secondo il diritto nazionale. Quindi anche nel diritto italiano quelle procedure di concordato che sono aperte appunto sia nel giudizio di primo grado ma anche nel giudizio di secondo grado attraverso l'articolo 599 bis del codice di procedura penale saranno ugualmente applicabili nei procedimenti di competenza della Procura Europea. Da sottolineare anche che, pur in mancanza di questa armonizzazione di cui vi ho parlato, è prevista per tutte quelle procedure di concordato che siano applicabili che laddove le frodi ai danni del bilancio comunitario abbiano ad oggetto spese, quindi siano effettuate sul versante delle uscite, il procuratore europeo delegato incaricato del caso, prima di proporre una procedura di concordato, deve consultarsi con le autorità nazionali incaricate per appunto concertare con le stesse la applicabilità delle procedure. Per quanto riguarda i criteri da seguire in questo caso, sempre l'articolo 40 del regolamento prevede alcuni criteri che vengono specificamente indicati: la gravità del reato innanzitutto, sulla base del danno arrecato, la volontà dell'indagato di riparare il danno causato dalla condotta illecita, la conformità del ricorso a questa procedura con gli obiettivi e i principi di base della Procura Europea. E ancora il testo dell'articolo 40 prevede la possibilità per il collegio della Procura Europea di adottare direttive in questa materia. Da notare ancora infine che il procuratore europeo delegato non può da solo decidere il ricorso a queste procedure, ma in ogni caso deve chiedere l'accordo della Camera permanente. Non è qui il momento per entrare nella descrizione del funzionamento della Procura Europea, ma è importante appunto ritenere che il procuratore europeo delegato che conduce l'indagine non può decidere da solo, ma ha bisogno dell'autorizzazione della Camera permanente. Come vi dicevo, l'articolo 40 autorizza il collegio a adottare delle direttive in questa materia, e queste direttive sono state adottate dal collegio con una decisione del 2 dicembre del 2020, che è una decisione adottata proprio sulle procedure semplificate e sulla delega dei poteri da parte delle Camere permanenti. In questo modo il Collegio della Procura Europea ha sostanzialmente adottato dei criteri per il ricorso a queste procedure di concordato, su queste procedure semplificate, e che si richiamano in parte a quelle del regolamento, si richiama ancora una volta la gravità del reato, ma sottolineando che questa gravità in quanto tale non deve essere, recita la decisione, non deve essere un impedimento ab initio, questo si usa il termine latino nel testo inglese di queste direttive, ad applicare procedure semplificate, vale a dire che il fatto che un reato sia grave, sia oggettivamente grave, comunque non impedisce la possibilità di ricorso a queste procedure, purché, recita ancora le direttive del collegio, il diritto nazionale consenta in qualche modo il ricorso a queste procedure. Quindi se il diritto nazionale prevedesse un tetto di gravità, per esempio per l'importo del danno arrecato, queste procedure ovviamente non sarebbero applicabili laddove questo importo fosse superato. Altri criteri richiamati in queste direttive del collegio sono quelle, appunto, il richiamo ai principi di obbligatorietà dell'azione penale che è previsto nei considerandi del testo del regolamento, il richiamo al principio di proporzionalità, ma anche il ricorso a quello che le stesse direttive chiamano un principio di opportunità, vale a dire prendere in considerazione ulteriori criteri e soprattutto recitano sempre queste direttive il fatto che l'applicazione di queste procedure semplificate sia coerente con la effettiva protezione degli interessi finanziari dell'Unione Europea e con i principi di proporzionalità e di imparzialità. Quindi questo è il criterio che il collegio detta appunto ai procuratori europei delegati nel considerare il ricorso a queste procedure, la coerenza con un'effettiva protezione degli interessi finanziari, ma attenzione, vi è anche un altro criterio che a mio avviso è di particolare importanza ed è quello che sempre nel linguaggio inglese adottato dalle direttive si chiama fairness towards the defendants, vale a dire la correttezza nei confronti degli accusati. Questo è molto importante perché introduce un criterio che non è presente nel regolamento, ma che è estremamente importante dal punto di vista delle garanzie difensive, che per la verità non sono particolarmente presenti nel testo del regolamento sulla Procura Europea, ma che acquisiscono ovviamente un'importanza crescente nel dibattito, i diritti della difesa. Ancora ed infine l'interesse pubblico da tenere in considerazione nel possibile ricorso alle procedure semplificate deve essere appunto accertato non soltanto da un punto di vista, dicono le direttive, nazionale, ma anche da una prospettiva di diritto unionale, dalla prospettiva dell'Unione Europea. Ecco, quindi infine le direttive si concludono con le indicazioni per i PED per queste consultazioni con le autorità nazionali che sono obbligatorie, come ho detto prima, quando si tratti di frodi alle spese, prevedendo che le stessi appunto assegnino un termine di 30 giorni alle autorità nazionali per rispondere. Ecco, questo in una noce, come si dice, il contenuto essenziale delle procedure appunto semplificate nel regolamento EPPO. Come vedete molto interessante e integrato da queste direttive adottate del collegio. Ma io vorrei anche presentarvi invece questo studio dell'OCSE adottato nella sede del gruppo di lavoro sulla corruzione internazionale dell'OCSE, appunto di cui, come si ricordava, sono il vicepresidente. È uno studio del 2019 abbastanza corposo, proprio sulle quelle si chiamano, vengono indicate non trial resolutions systems, vale a dire i sistemi di risoluzione dei controversi non attraverso il processo. È uno studio che è concentrato sulle casi di corruzione internazionale, ma che contiene considerazioni molto interessanti. Copre 27 paesi sui 44 paesi che sono parte alla Convenzione dell'OCSE del 1997 sulla corruzione internazionale e ci rivela come per tutti praticamente questi paesi la fonte primaria nel risolvere i casi di corruzione internazionale siano esattamente procedure semplificate oppure non trial resolution appunto per la grande maggioranza di questi paesi. Dei 23 paesi sui 44 che sono parte alla Convenzione che hanno concluso con successo una procedura penale per corruzione internazionale, nel 78% dei casi si sono adottate procedure appunto semplificate, non trial resolution. Quindi questo che cosa vuol dire? Che i procedimenti per corruzione internazionale nella stragrande maggioranza, praticamente in 3/4 dei casi, si sono risolti con procedure al di fuori del processo tradizionale, mentre il 22% hanno conosciuto un procedimento tradizionale attraverso appunto il processo, lo strumento del processo. Quindi, prima conclusione, una stragrande maggioranza di procedimenti risolto attraverso non trial resolution systems. E di questi sempre 22 paesi che hanno portato a termine con successo procedimenti, ben 7 hanno fatto ricorso esclusivamente a procedure diverse dal processo. 8 stati hanno usato tanto strumenti processuali, tanto strumenti non processuali, e tra questi 8 stati rientra anche l'Italia, mentre altri 8 stati hanno fatto ricorso esclusivamente a strumenti di natura classica, chiamiamo così, processuale, quindi sono andati esclusivamente attraverso il processo. Importante è anche la considerazione contenuta nello studio per cui queste procedure semplificate hanno consentito di coordinare processi cosiddetti, non processi, ma procedure multigiurisdizionali, vale a dire che hanno coinvolto più paesi, e questo coordinamento, ci dice lo studio, non sarebbe stato possibile se fossero stati adottati strumenti di natura classicamente processuale. Il caso di Siemens AG del 2008, che è un importante caso di corruzione internazionale, ha visto per esempio lavorare insieme Stati Uniti e Germania con successo, e appunto lo studio, come dicevo, conclude nel senso di dire che non sarebbe stato ciò possibile ove fossero stati condotti tradizionali strumenti processuali. Ovviamente un'altra delle conclusioni dello studio è che uno dei principali fattori di attrazione per il ricorso a queste procedure è la possibilità di adottare, di avere sanzioni ridotte rispetto a quelle che verrebbero adottate alla fine di un processo di tipo tradizionale. Ma attenzione, anche qui su questo concetto di riduzione delle sanzioni passiamo dal più alto livello di sanzione adottato, che è di ben 3,2 miliardi di dollari adottato in un procedimento Odebrecht che ha visto coinvolto appunto Stati Uniti, Brasile e Svizzera, fino a quello che è il più basso livello di sanzione, che è di un franco svizzero adottato in un caso in Svizzera, quindi un amplissimo range di sanzioni. È chiaro che il fattore di attrazione, la carota, come potremmo dire, è dato dalla possibilità di sanzioni ridotte, ma ovviamente queste sanzioni sono anche molto elevate. Tralascio sui fattori determinanti appunto che devono condurre a queste procedure semplificate, ma anche qui si richiama la gravità del reato, l'interesse pubblico, gli elementi, la forza della prova, della evidence a disposizione, eccetera, e mi concentrerò su un fattore molto importante che è il principio no incentive without deterrence, vale a dire che gli incentivi costituiti da queste procedure di concordato non devono essere disgiunti dalla deterrenza, vale a dire che il soggetto che viene possibilmente chiamato a fare ricorso a queste procedure deve ovviamente avere qualcosa da temere nel caso in cui non si faccia ricorso a una procedura semplificata, ma si vada invece verso il processo tradizionale. E questo è molto importante perché ovviamente ove il processo tradizionale costituisca un'arma spuntata, sarà molto difficile che i soggetti, siano esse persone fisiche o persone giuridiche, facciano ricorso adesso, perché se non hanno hanno nulla da temere dal processo di natura tradizionale, non si vede perché dovrebbero fare ricorso a procedure più veloci che si concludono ovviamente in maniera molto più rapida e semplificata. Ecco, questo è molto importante anche proprio nella situazione italiana, ovviamente, dove i nostri processi, come si sa, sono lenti e possono non costituire un efficace deterrente per le persone fisiche e le persone giuridiche coinvolte e quindi non costituire un incentivo a fare ricorso a procedure alternative, a procedure semplificate. Per quanto riguarda i soggetti che possono imporre sanzioni, vediamo che il pubblico ministero, le autorità di prosecution giocano un ruolo essenziale nel 71% dei casi e addirittura nel 38% dei casi hanno un esclusivo potere di decidere sul ricorso alle procedure semplificate. E invece, dall'altra parte, le corti, quindi gli organi giudiziari, hanno un ruolo non esclusivo, vale a dire che concorrono col pubblico ministero nel decidere soltanto nel 50% dei casi e addirittura hanno un ruolo esclusivo nel decidere soltanto nel 15% dei casi. Quindi la lezione qui da ritenere è che il pubblico ministero gioca un ruolo assai più importante delle stesse autorità giudiziarie nel decidere su questi procedimenti e su queste misure alternative. Queste corti, a loro volta, nei casi in cui abbiano competenza, attenzione, hanno una competenza nel merito, vale a dire la possibilità di rivedere i fatti soggiacenti soltanto nel 21% dei casi soggetti alla loro revisione, mentre invece appunto nel restante numero dei casi si limitano a verificare i presupposti formali. Per quanto riguarda le possibilità di appello, nel 52% dei casi queste procedure possono costituire oggetto di appello, nel 42% dei casi non hanno possibilità di appello. Mi avvio alla conclusione perché i 20 minuti stanno andando a scadere. Ricordo un altro fattore di importanza che è la possibilità di un controllo pubblico, di una trasparenza di queste procedure. L'OCSE nelle proprie valutazioni, procedure di valutazione, chiede sempre che sia garantita un minimo di trasparenza e di accessibilità, vale a dire la possibilità di conoscere che queste procedure semplificate vi siano innanzitutto, ma anche di avere accesso alle ragioni, alle motivazioni che hanno condotto all'adozione della decisione finale. E infine anche il problema di debis in idem, vale a dire in che modo queste procedure possano costituire appunto una procedura che poi impedisce l'adozione di ulteriori decisioni nei confronti delle persone fisiche o giuridiche che sono passate attraverso le stesse e circa il 60% dei casi esaminati queste procedure costituiscono un debis in idem. Concludo nel rispetto dei tempi. Come vedete, molti di questi dati che ho fornito mi sembrano comunque interessanti anche per quella che sarà, soprattutto nel futuro, l'esperienza della Procura Europea, il carattere comune a tutte queste procedure, che si tratti di inchieste per frodi ai danni degli interessi finanziari dell'Unione o casi di corruzione internazionale, che si tratta di procedure complesse, di reati difficili da indagare e che proprio in quanto tali possono incitare alla possibilità di fare ricorso a procedure alternative. Ovviamente la mancanza di armonizzazione, appunto quell'armonizzazione che non è stata realizzata con il regolamento sulla Procura Europea, può condurre a possibili difformità nelle applicazioni nazionali, in quanto appunto in alcuni stati partecipanti alla Procura Europea sarà possibile fare ricorso a queste procedure ed in altri no, ma comunque anche alle procedure EPPO mi sembra essenziale mantenere a mente quel principio che ho citato io, no incentive without deterrence, vale a dire che ovviamente vi deve essere un incentivo soltanto nella misura in cui le procedure nazionali ordinarie, i processi penali davanti all'autorità giudiziaria nazionale costituiscano un effettivo strumento di deterrenza. Se non vi sarà qualcosa da temere per portare i processi fino in fondo, non vi sarà, a mio avviso, un ricorso a queste procedure alternative. Quindi l'efficienza dei processi nazionali gioca una irrilevanza estrema. Con questo concludo e credo di aver rispettato il tempo a mia disposizione e vi ringrazio.
Grazie, thank you to Lorenzo Salazar for his illuminating presentation and for driving the attention on this interesting study carried out by the Organization for Economic Cooperation and Development on resolving foreign bribery cases with non-trial resolutions. It was published in 2019. I don't know whether it is open access or not. I had it and non so se lo studio è online.
Dunque sì, è tutto, chiedo scusa, avrei dovuto dirlo. Sotto il sito del working group, io ho già trasmesso innanzitutto il PDF, quindi potrà essere messo a disposizione, ve l'ho mandato a Maria Mercedes, e comunque tutto accessibile sotto il sito del working group on bribery dell'OCSE, OECD, quindi basta digitare OECD WGB, working group on bribery, e avrete accesso a tutta la documentazione, per cui non soltanto questo studio, ma una serie di studi estremamente interessanti tratti dalla esperienza enorme accumulata dal Working Group on Bribery appunto nelle procedure di valutazione in materia di corruzione internazionale.
Grazie. So the study is open access, but we will also put it in the DRUMP website because it's very interesting. We learned from Dr. Salazar that the 78% of cases of non-trial resolutions, out of only the 22% of cases that went through trial, and nearly half those cases of NTR procedures do not go to the appeals phase. So this is very interesting, including the highlighting of the principle of no incentive without deterrence. Grazie mille, Dr. Salazar. I hope that spero che lei possa contribuire. Non si sente lui? Che lei possa contribuire agli atti del convegno con un testo scritto della sua presentazione. Grazie ancora a nome di tutti.
Grazie a voi.
And finally, for this panel, then we'll go for intervention and then the coffee break. Anche gli studenti naturalmente sono invitati al coffee break e al lunch, lo volevo dire. Now I give the floor to my colleague Simone Vezzani, who is a professor of EU law and international law in this department, where he has a long teaching experience. He got his PhD in international and EU law in the University of Florence in 2008. He's a member of several research projects in different areas of research, from the sustainable management of natural resources to claims against acts of international organizations, from the European Court of Human Rights cases to the financial crimes. He's the author of many publications in scientific journals and 2 books. And today he will tell us about the relationship between EPPO and the Charter of Fundamental Rights, because as has been highlighted by Dr. Salazar, the regulation, the EPPO regulation did not sufficiently develop the provisions on the right of the accused. And so we will see how this principle of fairness toward the defendant can be complied with within the Charter of Fundamental Rights of the European Union. Simone, you have the floor. Thank you for being here.
So, thank you very much, Alessandra. And first of all, just let me thank all the guests and speakers coming from so many European countries. So as it has already been underlined, the EPPO, please let me call it EPPO, that constitute an unique and a very special example of cooperation in criminal matters, a revolutionary example, as Dr. De Angeli has said. And this is very different from more traditional horizontal cooperation in criminal matters between EU member states. And it also represents a unicum at the international level. Of course, international lawyers are familiar with international criminal courts and tribunals, but here the specificity, and also mixed criminal tribunals. But here the specificity of the EPPO is that states have transferred sovereign powers to an EU body by giving to this body investigatory and accusatory competencies, but this prosecutor is making use of tools and powers provided by very different national legal systems, and the trial is regulated by domestic law in front of domestic courts. And so this gives rise to many complexities which are of utmost interest for international and EU lawyers, also as far as human rights are concerned. I have divided my presentation into 4 parts. In the first one, I'm going to discuss the impact on fundamental rights of EPPO activities, and I will mainly focus on the role of the EU Charter of Fundamental Rights. In the second part, I will discuss judicial review of EPPO decisions, which is also useful to understand the legal nature of this very strange and sui generis body. In the third and main part, I will discuss issues relating to international responsibility, the attribution of international responsibility. In case of human rights violations, who is to be held responsible, the EU or the member states where the investigation and the following trial is carried out. Finally, time permitting, I will just make a few considerations on diversion and other alternative forms of negotiated justice, because the point I would have liked to make has been already made by Dr. Salazar indeed. So coming to the first part of my presentation, of course, EPPO needs to balance 2 different objectives. From one side, combating crimes through effective investigation and prosecution activities, but this has to be balanced with due protection of fundamental rights. It is quite clear that very intrusive measures also in the pre-trial inquiry can have a very relevant impact on fundamental rights of all the persons involved in the proceedings. And of course, I'm thinking firstly of the suspect or accused persons, but also the rights of the victims are at stake. Of course, when you're talking of PIF crimes, the main victim is the EU itself, but we can also have other individuals which are the victims of PIF crimes. Just like consider the example of misappropriation of funds from the EU budget. funds which would have been destined to, for instance, a private corporation which is the victim of the thief crime. It has already been underlined that we do not have an European Criminal Code of Procedure regulating the activities of EPPO, so which has to work with 22 different legal systems, which have been only partially harmonized. Of course, we know that there are many directives dealing with the rights of the defendants in criminal trials, as far as legal aid, access to lawyer, and presumptions of innocence are concerned, but all these directives just set minimum standards. So the rights of defense, the fairness of the procedure varies quite a lot from one country to the other one, depending on the applicable law. I'm not going to discuss in detail all the relevant rights which can be affected by the activities of the EPPO. We have already mentioned the several rights to defense, the right to legal aid, the right to be informed, and so on and so forth. The ne bis in idem principle, of course. I would just like to emphasize that some possible violations are strictly connected to the very distribution of judicial powers, to the very structure and functioning of the EPPO and its normative complexity. In particular, I'm referring to the right to have the competent judge legally established, the principle of natural court, as we say in Italy, il giudice naturale. And in fact, in cross-border cases where more than one member states participating to the enhanced cooperation has jurisdiction over the same facts, there is a certain discretion which has been left to the EPPO to decide in which court an accused should be brought to trial. And of course, several problems are also posed in case of reallocation of the case. So as a general rule, usually the member state of the European delegated prosecutor which conduct the investigation is the same where the trial occurs, takes place. But the possibility of reallocation to another country is also possible under the EPPO regulation. As it has already been said, there are few references in the EPPO regulation to fundamental rights. Of course, we can find this provision. You can read here mentioning the charter with specific regard to the rights of suspects and accused persons. Indeed, they are quite superfluous because we know that the charter has the same legal values as the treaty, so it applies independently from these provisions. And also the European Convention of Human Rights is mentioned in the preamble of the EPPO regulation. As I was saying, the charter applies to these proceedings according to Article 51, paragraph 1 of the charter itself, under which the charter applies to the institutions and bodies of the Union. This is the first part of this paragraph, and it also applies to member states in the implementation of Union law. I will discuss later on which is the nature of European delegated prosecutors. Are there EU organs or are there state organs? But independently from this, it is clear that the activities of EPPO are regulated by the Charter. And many provisions of the Charter are relevant. Article 47, relating to due process, Article 48, presumption of innocence, the bis in idem principle, but also other provisions of the Charter. For instance, Article 7, Article 8, about the right to privacy and the right of protection of data, and also the right of the child. And we should be also consider that apart from the Charter, the EU is a contracting party to the UN Convention on the rights of persons with disabilities, which also contains provisions about access to justice. I'm not discussing the hybrid nature of the EPO, but I would, since now, clarify that there's no doubt that the central EU level, European layer of EPO, can be certainly qualified as belonging to the EU. It's a really EU body. The problems rather relates to the decentralized level, delegated European prosecutors, and also national enforcement authorities, should there be considered organs of the EU when they are acting under the instruction of delegated European prosecutors, and so on and so forth. I will discuss this in the third part of my presentation. But I would like to emphasize here the role of domestic courts, which must adjudicate on the merits of the case. Of course, in many cases, investigation measures are subject to prior judicial authorization. This depends, of course, from applicable domestic law. As I said, the subsequent trial follows domestic rules, but the very circumstance that all these trials concern thief crimes makes the charter applicable according to a settled case law of the Court of Justice. I'm referring here to the very well-known and seminal judgment, the Franson ruling. So this has several implications. National criminal procedural law must be interpreted during the whole proceedings in conformity with the Charter. And as we know, this also implies then when a conflict between national provisions and the Charter arises, the competent judge, the competent national court is called, if necessary, to disapply domestic law provision. So just let me move briefly to the second part of the presentation, dealing with judicial review of EPO, X, and decision. As a general rule, judicial review is entrusted to national courts, and the Court of Justice just plays a very limited role, as we will see in a few moments. And so there is a sort of legal fiction, as some author has put it, that is to say, EPO is considered as a national body for the purpose of judicial review. And the possibility of national courts to decide on the validity of EPO X and decision also represent a departure from a traditional principle of constitutional EU law. I'm referring to the seminal Photo Frost judgment, according to which national courts can never declare invalid an EU law act. Here you can see Article 42, as I have said, this provision confers judicial scrutiny to competent domestic courts. As a general rule, we have a few exceptions. For instance, the Court of Justice is competent to rule on the legitimacy of the decision to dismiss a case, and it has also competence relating to compensation for damages caused by the EPO. Of course, the second paragraph you can read here also provides that the Court of Justice has jurisdiction to give preliminary ruling. It is quite obvious that this jurisdiction exists when the interpretation or the validity of the EPO regulation is at stake. So letter B and C are quite superfluous once again. What is not superfluous is letter A, because according to this provision, there is the competence of the court as concerned the validity of procedural acts of the EPO insofar as the question of validity is raised on the basis of EU law. So we have this very strange system according to which, as a general rule, the acts of EPPO are considered as national acts, but when the validity of this act is based upon EU law provisions, the nature somehow of these acts turns into an EU act, so that we have the jurisdiction of the EU, because as a general rule, the Court of Justice has no competence to rule on the validity of domestic law provisions. This is very strange, but we can easily understand why this solution was adopted in this regulation, because the Court of Justice is not a criminal court. It does not even has the necessary expertise, and national courts have access to the file. We would attributing jurisdiction to the Court of Justice for all cases would also result in the court being overwhelmed. And so that's why the regulation has attributed limited competence to the court. Just let me move to the third part of the presentation, international responsibility. As I said before, the problem is who is to be held responsible, the union or the member states where the investigation is carried out. This might seem a merely theoretical problem, but this is not the case, because the problem is, may the defendant, the accused person, bring proceedings before the Strasbourg court against the state? Because we know that actually the EU is not a contracting party to the European Convention of Human Rights. A very simple question, answer might be that the EPPO, including European delegated prosecutors, are EU organs whose conduct is attributable to the EU, even if they are applying a domestic law provision. And this has also implication as far as ultra vires conducts are concerned. What if an European delegated prosecutor does not follow the instruction of the permanent chamber and of the supervising European prosecutor? Is there nevertheless the responsibility of the union? The answer is yes, if we consider the European delegated prosecutor as an EU organ. But this solution has some fallback, I would say, because a member state might try to escape responsibility by saying that only the EU is to be held responsible. For instance, it may also invoke the Bosphorus presumption, or it might say that enforcement domestic organs are simply acting under the control, under the instruction of the EU. So there's no responsibility of the state for violation of the European Convention of Human Rights. Another possible solution is to consider European delegated prosecutors not as EU organs, but as state organs. And indeed, we have to consider that European delegated prosecutors are and remain part of the domestic prosecution services. They continue to be paid by the state. They have all the rights and duties connected to the status as member of the European Prosecution Service. So if we consider the European delegated prosecutor as an state organ, we may consider this state organ as an organ which is put at the disposal of an international organization. Here you can find some articles taken from the ILC draft articles on the responsibility of international organizations, which is a soft law instrument. This is a not binding instrument which has been adopted by these United Nations commissions. It is not binding, but it is often quoted by international courts and tribunals as reflecting, at least in part, international customary law, because it has been adopted by very distinguished scholars, which are the members of this international commission. And so if we consider European delegated prosecutor as state organs put at the disposal of the EU, this has several implications. For instance, ultra vires conduct are not attributable to the EU, but remain attributable to the member states. And of course, this is particularly relevant in cases where the measures are adopted without the authorization of domestic courts, because there's no doubt that domestic courts are state organs. So if they authorize certain measures infringing upon fundamental rights, there is state responsibility. I think I have run out of time. I would just like to say a very few words about simplified procedure, which are the one we are studying today and tomorrow. Also, recourse to this kind of procedure, diversion, mediation, and so on and so forth, there is the necessity to respect fundamental rights guaranteed under the Charter, as far as the right to appoint a lawyer is concerned, the right to obtain legal aid if necessary, the right to be informed, and so on and so forth. It has already been said that finally no transaction uniform rules were adopted at the EPPO level. So once again, we have to make reference to domestic law, which are very different, but here it is the European delegated prosecutor which has to propose to grant diversion or other procedure of this kind, but the responsibility for the decision lies with the central European level, the permanent chamber. And it has already been mentioned that Article 40 of the EPPO regulation provides for the adoption of guidelines. And here I refer to what Dr. Salazar has already said. We can find in this guideline reference to the fairness of the procedure. So European delegated prosecutor and the chamber, the competent permanent chamber, have to abstain to use this kind of procedure if they are not in conformity with the Charter. On the other hand, there is a lot of discretion which is left to European delegated prosecutor to make recourse to this kind of procedure. So this was the only point that I would like to make about this. And I'm sorry for having run out of time, and so I really thank you for your attention.
Grazie mille. Thank you very much, Simone, for your presentation. You highlighted issues relating to the responsibility for the conduct of the deputy prosecutors within EPPO. You raised several issues, and I don't know whether there is somebody who wants to ask questions now, or we leave it for later. I invite you to further develop your consideration in the writing version of your presentation in the proceedings. Grazie ancora. So if there are no questions or intervention, we now move to a room on the left-hand side of this building for coffee break. And we will resume, let's say, what time is it now? Within 20 minutes at maximum. Grazie. Gli studenti anche sono invitatissimi al coffee break, tutti quanti.
Gentlemen, let's start. We don't have too much time. I'm very pleased to see that our students again are there. Welcome. Thank you very much. And since we have so many speakers, well, as chairman, we have to impose discipline, but it's difficult to impose discipline when, as speaker, I myself I was not so disciplined. But maybe what you can say in 20, you had prepared for 20 minutes, you can say the same 50 minutes. I don't know if you succeed. I don't want to impose you my rules. I just want to say only one sentence that it is interesting the impact, I mean, the debate about this topic, because the Minister of Justice, 9th July in Helsinki, on the role of alternative sanction to prison criminal policy of states, Minister considered that a political agreement on this issue would provide at least a partial solution to the problem of prison overcrowding, which affects mutual trust and mutual trust and undermines judicial cooperation between member states. The Council takes note of alternative measures already in place, but notes that significant gaps need to be filled. An operational solution remains to be found in cooperation with Council Europe and other organizations. So what we discuss here is a real political, real impact. And the Minister of Justice have dealt with the problem, a linked problem of possible solution with alternative sanction to overcrowding of prison. So it is important to note that all these have, as I said, practical impact. Now we have three speakers from Rouen, online. The Romanian speaker, Anca Jorma. Good afternoon, no, good morning still. Nice to see you. Radovan Blazek, you are there? Yeah, no.
Yes, I'm here. I'm online.
È quello che dico. Volevo salutarli. Ok. And Olga Sobova.
Hello, nice to meet all of you, especially you, Francesco. Hello.
Nice to meet you. Okay, let's start, and then I will introduce you later on, because now we have a special link with some countries. So, Anca Jorma, please.
Buongiorno a tutti, grazie a professor Lanciotti e all'Università di Perugia per avermi invitata a questo molto interessante progetto e conferenza. Saluto anche Dr. De Angelis, and now I will switch to English. I will try as much as I can in 20 minutes to give you an overview of the Romanian legislation with regard to the simplified and alternative procedures in the prosecution of EU financial crimes. Let me see if I can share my presentation. I think.
Si vede di là, sia?
Yes.
Bisogna ingrandire o come?
Something is okay. Just a second. Okay, now it should be okay. So with regard to the PIF offenses, in Romania, the criminal offenses against the financial interest of the EU have been introduced in 2003. A section of the anti-corruption law has been dedicated to the PIF offenses. With the adoption of the PIF directive, some new amendments have been brought to the law, but the architecture of the incriminations remained basically the same. However, when it comes to the VAT fraud, we apply the tax evasion law. Since June 2019, when EPPO took over the bulk of the competence of on PIF offenses, the National Anti-Corruption Directorate, our office, and the other prosecution offices continue to investigate and prosecute only the PIF cases that do not fall under EPPO's competence and the cases that have not been evoked by it. When investigating and prosecuting the EU fraud cases, our national prosecutors are commonly using, whenever the legal conditions and the factual circumstances allow, the alternative and simplified procedures that they considered fit for the case. The EDPs could also use them. However, currently, the European delegated prosecutors in Romania did not conclude any cases yet. These alternative procedures are not different in PIF cases as compared to other cases, but some of them are used more often than the others. Traditionally, the Romanian criminal legal system did not recognize any form of negotiated justice, having at the top of the fundamental principles of the criminal procedure a very strong principle of legality, of mandatory prosecution. Negotiated justice did not seem to find its place. Some form of alternative dispute resolutions existed, though, for the underage offenders who could have been sanctioned with educative measures instead of criminal punishments. The first breakthrough was brought by the adoption of the law on mediation in 2006, which introduced the first form of alternative dispute resolution in our legislation, applicable in civil, but also to some extent in penal matters. The use of mediation in penal matters is very limited, though. It is applied only for less serious offenses for which the criminal action depends upon the victim pressing charges, or when the criminal action is closed based on the conciliation between the victim and the offender. And the PIF offenses do not fall under this category. But then in 2014, with the entry into force of the new criminal procedure code, the window was more open to embracing the concept of alternative dispute resolutions in criminal matters, together with the introduction of the principle of opportunity in strictly limited situations. The following procedures currently in force in the Romanian legislation in criminal matters can be considered as pertaining to the notion of alternative dispute resolutions and or simplified procedures. And I will go through each of them. Out of these 5 procedures, one of them cannot be applied in the cases concerning offenses against financial interests of the EU. With regard to penal accusations, and this is the mediation. Therefore, I will skip presenting details about it. So, waiving the exercise of the criminal action for lack of public interest. The new Criminal Procedure Code introduces for the first time in the Romanian law the principle of opportunity, which attenuates the traditional mandatory prosecution principle. Thus, in the cases and under the conditions expressly provided by the law, the prosecutor may waive the exercise of the criminal action if, based on the concrete elements of the case, there is no public interest in the prosecution. The discretion of the prosecutor is not absolute. His ordinance has to be confirmed by the judge of preliminary chamber. When deciding to waive the exercise of the criminal action, the prosecutor may also order the suspect to fulfill some obligations, for instance, to repair the damage caused, or to agree with the civil party a way to repair it, and so on and so forth. This procedure may be applied only for offenses sanctioned by the law with a maximum of 7 years imprisonment. Thus, it can be applied to all of the PIF offenses provided in the anti-corruption law and to the offense of bribe giving, as they are punished with less than 7 years. However, the cases of tax evasion, of bribe taking and money laundering cannot be terminated for lack of public interest, because the maximum penalty for them is higher. In practice, the number of cases terminated with the waiver of criminal action is not very high. They usually are very de minimis cases. For instance, out of 124 PIF cases provided by the anti-corruption law sent to trial by DNA, our office, in 2021, the prosecutors waived the exercise of the criminal action only in 7 cases. That means around 5%. The next one, the agreement of admission of guilt, AG, is the most frequently used alternative procedure in PIF cases. This is an agreement concluded between the prosecutor and the defendant, by which the defendant admits his guilt and accepts the legal qualification of the deed and the application of the punishment proposed by the prosecutor. In exchange, the defendant benefits of a reduction with 1/3 of the limits of imprisonment penalty provided by the law. An agreement can be concluded only for offenses for which the law provides a penalty of maximum 15 years imprisonment. And that means it's applicable for all the PIF offenses. One very important condition is that there should be sufficient evidence that could secure a conviction. The agreement should be approved by the superior prosecutor and confirmed by the court. The court verifies the compliance of the agreement with the legal requirements, including the validity and legality of the consent expressed by the defendant. And the defendant cannot retract his consent. This is irrevocable. In the 8 years since the adoption of this concept in the Romanian criminal law, the prosecutors and the courts applied it very often and successfully. Nevertheless, this concept is not spared of controversies. There are still some voices in the doctrine that have a critical view with regard to this imported concept, departing from the traditions of the national criminal law. Some authors consider that the agreement is affecting the principle of separation of the judicial functions. Thus, the court does not have the possibility to verify the legality of each piece of evidence and of each procedural act to determine or to change the legal qualification of the offense, the type and the quantum of the penalty, etc. It has only the prerogative to admit or reject the solution provisionally adopted by the prosecutor. However, this opinion does not stand because the law already provides that the judge can reject the agreement altogether if he deems that is illegal in any aspects. And on the other hand, it is obvious that introducing such requirements would devoid the simplified procedure of its very essence. Another disputed aspect with regard to the AAG is the situation in which multiple individuals jointly perpetrate the same offense and only one or some of them conclude an agreement. The law stipulates that if some of the defendants concludes an agreement, the prosecutor cannot send to the court procedural acts referring to the other defendants that are not covered by agreement, and that the presumption of innocence of the other defendants or suspects should be observed. This issue concerning the observance of the presumption of innocence and the apparent incompatibility of the judge who ruled on the agreement to rule on a separate procedure concerning the participants who did not prevail themselves of this simplified procedure have been raised by the jurisprudence and the doctrine. And we have a decision of the Constitutional Court in 2020 saying that the decision of a court to convict a participant does not affect the impartiality of the judge in resolving the case regarding the other participants, given the personal nature of the criminal liability. However, this issue remains sensitive, and as the doctrine highlights, it is necessary for the text of the agreements and of the court decisions admitting them to expressly mention that the guilt of the other participants to the offense who have chosen to follow the regular procedure has not been established and that they are the object of a distinct criminal procedure. Another aspect that deserves a comment in relation to the AAG is the recovery of the damage. The settling of the civil claims is not a legal precondition for the prosecutor to conclude an AAG with the defendant. If there is no transaction between the parties, the civil claims remain to be solved through a separate procedure in front of the civil court. Although the settlement of the civil action is not a legal condition for concluding an AAG, it is instead a common practice for the prosecutors, and especially in the PIF cases, to enter into negotiations for an agreement only after the defendant has willingly recovered the damage caused by the offense, or if the assets already seized during the criminal investigation are enough to cover the damage. It pertains to the opportunity of entering into an agreement. Another procedure is the so-called abbreviated procedure in case of admission of the accusation before the court. This is a simplified procedure rather, and in its essence, it provides for the possibility for the defendant to request during the first hearing of his case in the first instance that the investigation takes place, that the judgment takes place only on the basis of the evidence collected during the criminal investigation and possibly other written evidence presented at this hearing by the defendant and other parties. If he uses this procedure, the defendant benefits of a reduction of the penalty with 1/3. This procedure is applicable for all the criminal offenses that are not punished by life sentence, therefore for all the PIF offenses. There are similarities, but also differences between the abbreviated procedure and the agreement of admission of guilt. Both procedures are based on the admission by the defendant of his guilt. However, while in the case of the AAG, the admission of guilt is the result of a negotiation process with the prosecutor, in the case of abbreviated procedure, the defendant alone decides freely to admit all the offenses of which he is accused. If all legal conditions are met, the court cannot refuse the defendant the benefit of the abbreviated procedure, while the AAG is not a right of the defendant. The civil action, if attached to the penal action, will be solved under the regular procedure. However, as we have seen in practice, the interest of the defendant who admitted his guilt to benefit of an even lesser punishment is usually determining him to recover the damage before the end of the penal trial. Last but not least, and this is the most controversial procedure, impunity and mitigation clause in tax evasion cases. This clause targets specifically the recovery of the damage. With regard to the PIF offenses, this procedure could be used in VAT fraud. The law on tax evasion suffered several amendments in 2021 that brought mitigations of the penalty and impunity in certain conditions if the damage caused was recovered. According to a first amendment brought in March 21, which is no longer in force but opened a huge controversy in a case of tax evasion, if during the criminal investigation or the trial until the ruling of a final court decision, the damage caused by the perpetrator of an offense increased by 20% of the calculation base, to which there are added the interest and penalties. If this is fully covered, the offense is no longer punished. Another amendment was introduced providing for mitigating penalties in case of the recovery of minor damages under 100,000 euros. But the amendment introducing the impunity clause was received by the legal professionals and by the public in general with a strong negative opinion. The fact that the impunity was granted regardless the value of the damage caused which could be of millions of euros, was heavily criticized, having in mind that the capacity of the administrative authorities to identify and prevent tax evasion from occurring is rather limited. While one might reasonably expect that the people willing to commit tax evasion would be encouraged to continue to do so, assuming the risk that in the unlikely event of being caught, they could escape the criminal responsibility by paying the damage and a surplus of 20%. Following this criticism, the law was amended again in December 21, and currently the impunity clause can be applied only in cases in which the damage caused did not exceed 100,000 euros, and only for the first offenders. The other legal provisions, the mitigating ones, remain unchanged. This new amendment was better received by the practitioners. However, due to the application of the Meteor Lex principle, the March 21 law will still be applicable for the offenses committed before December 21. As a conclusion, the ADR procedures applicable to the PIF offenses, and not only to those offenses, when wisely used, are expected to bring a better use of the justice system and a better response to the law infringements. They are mainly contributing to the deflation of the judicial activity, especially of the court's burden, to the increased celerity of the criminal procedure. Some are also targeting an improved rate of recovery of the damage. Last but not least, reducing the overcrowding of the penitentiaries and diminishing the recidivism rate is also envisaged. One of the important advantages of most of these ADR procedures that we noted in practice is the incentive that they bring to the defendant to recover the damage prior to the conclusion of the penal trial. There is no national study on the impact of the alternative dispute resolution procedures in the criminal justice in Romania, but I can extrapolate some data from the activity of DNA. For instance, the procedure in first instance, when the court is notified with an agreement of admission of guilt, usually takes no more than 1 month or a few months. And on the contrary, the regular trials may take 1 or more years in the first instance. Considering, again, the sample of data of DNA for 2021, out
Anka,
of the, yes.
Excuse me, you don't have time anymore. I think that all of us have the opportunity, will have the opportunity to read your entire contribution when proceeding is published. So can
I'm
you
finished.
conclude?
I'm finished.
You have only 2 seconds to conclude, please.
Yes, I'm finished. You can see the statistics on the screen. And I would conclude saying that the ADR procedures are beneficial. However, as we have witnessed in the relation with the March amendment of the law on tax evasion, such procedures could also be perceived in the society as an unjust response of the state to the financial criminality. Therefore, it is important to keep the right balance between a swift response to the criminal behavior, the retributive character of the sanctions, and the restorative and alternative dispute resolutions. Thank you.
Thank you very much. As I said, we all will have the opportunity to read your all contribution when the proceeding of this seminar are published. So stick to the essential of your contribution. Now, and now I give the word, the floor to Radovan Blažić, the University of Bratislava, Slovak Republic, of course. Please.
Thank you very much for the word. I am very pleased to have the possibility to contribute to the conference also via this online form. And I hope my presentation will be in this 15 minutes. So I hope I can manage do it in this time. So I will share my presentation. I hope everybody see it now. My presentation is called The Alternative Dispute Resolutions in Slovakia and the Effectiveness of Criminal Proceedings. So I will try to explain the types of alternative dispute resolutions in Slovakia. Then I will speak shortly about the negatives and barriers that usually are the point why we cannot use from objective grounds to use these alternative dispute resolutions. And then I will speak how it in practice works, this alternative procedure, and why I think that the prosecutors only very rarely apply these alternative dispute resolutions. So we have three main proceedings. Firstly, it is the conditional termination of the criminal proceedings. Then it is the reconciliation between the accused person and the victim. And then it is the plea bargaining. It is also the plea bargaining or the agreement on guilt and punishment between the accused, prosecutor, and the victim also participates on these proceedings. Anyway, what is the core element of the conditional termination of the criminal proceedings? It is the decision only for the minor crimes, minor offenses with the penalty rate of 5 years. It means that you cannot use it in all crimes. And there are also limitations that you cannot use it when there is a death of a person, in corruption cases, or prosecution against the public official. It means that you have limited possibility to use it in certain cases. Anyway, the accused must admit he committed the act, and then you can terminate conditionally the proceedings. It means that you will need to give the accused the probation period from 1 to 5 years, and you need to decide after this probationary period about the accused if he is okay or if you will continue with the proceedings. So the negative aspect of this conditional termination is that you need to make the second decision after the probationary period. Anyway, the necessary condition is that the damaged party must have the restoration. The accused must pay the money to the damaged party. So it is the condition which cannot be adhered in this case. It means that it is the necessary condition. When you have the reconciliation, it's similar to the conditional termination. It's for the same offenses. It means that the starting conditions are the same as the conditional termination. However, in this case, the outcome of this procedure is the final termination. It is not the conditional termination, but final termination. It's more positive decision for the prosecutor, because he doesn't need to follow the life of the accused after the probationary period and so on. So here the final closure is presumed, and the damaged party will have again his damage restored. And you have here such a survey. What is the difference? It is mainly these 5 conditions that in the first conditional termination, there is the conditional termination. In reconciliation is final. There is a probationary period from 1 to 5 years, and by reconciliation is no probationary period. In this conditional termination, you can add duties and obligations for the accused person that he needs to fulfill during this probationary period. And in reconciliation, he needs to pay a sum of money before the final termination of the proceedings. When you have the conditional termination, the accused and also the victim could file the remedy, and there will be the second level decision. In reconciliation, there is no remedy allowed, so the final decision is really final without any other possibility to change this decision. And for conditional termination, it's not necessary the victim's consent. However, by the reconciliation, you have the consent as obligatory condition for the decision. When we have the plea bargaining, it's the most used tool in the criminal proceedings because you can use it for all crimes. And the accused plead guilty, so there is a terminal closure of the proceedings, but he will receive the more favorable sanction in these proceedings, and damage could be or not could be restored. It is upon the decision of the accused person, actually, if he will or not will, if he won't or not want to restore the damage. And then it is necessary to approve this agreement between accused and the prosecutor by the court. Anyway, I will now explain what are the barriers that actually makes these alternative dispute resolutions not used in the criminal proceedings too much. First is that there are not many accused persons suitable for the procedure because we used it only for the criminals that have no criminal records. It is upon the judiciary prohibited to use against the persons who has committed the second, third, or fourth crime. So you have limited persons that could attend this procedure. And also the limitation with the crimes is the barrier to this alternative dispute resolution. And the third is that the condition in both in 216 and 220 is the paying of the damage. And the accused are very often the poor people from the lowest groups of society, so they don't have the money for paying the damage, and this is the obstacle for using this procedure. And what about the effectiveness? When you have this conditional termination, the problem is that it is not made by the prosecutor itself, but by the probationary officer of the court. So the prosecutor needs to send the file to the probationary officer, then the probationary officer makes all these administrative procedures, and he tries to agree with the victim and with the accused on the damage claim. When the damage agreement is applied, when the damage is restored, or when there is an agreement on the damage claim, then the prosecutor will issue the decision with 1 to 5 years probationary period. And after this period, he can decide the second time if the accused really is okay, and if he could terminate finally the proceedings, or if he will continue with the proceedings. Actually, it is very problematic and uncomfortable for the prosecutor, because when he filed directly the indictments on the court after the finishing of the investigation, he does not need to wait a couple of years to finish his case. So in these years, the prosecutor needs to wait 1 to 5 years, and then he needs to decide secondly. So it is very uncomfortable for the prosecutors, so they don't use it too much because they it is very big burden on their duties. When you have this reconciliation, again, the problem is that not many accused, not many crimes are suitable for this procedure. And again, the accused have not enough money. It's the same because the conditions in this part are similar. But there is another obligation to pay this sum of money for victims, additionally to the damage claim. So it is very often a big obstacle for this poor accused person to pay so much money. Even sometimes it is only like 500 euros, but they have really problems with it. And also the barrier is that legal successors of victims cannot agree on this reconciliation. They have only like the right for compensation. It is the right for compensation, but they have not status of victim in criminal proceedings. It means no procedural rights. So you can make this reconciliation only with the original victim of the crime. So what is the problem? Again, the whole procedure is made by the probationary officer, and there must be the agreement on the damage, and everything must be paid before the decision is made by the prosecutor. It means in the conditional termination of proceedings, the prosecutor could wait during this probationary period for the paying of all damage. In this case, because it's final decision, the prosecutor must wait until the damage is paid in the whole, and also the sum for victims is paid, and that could be very often long time because you give like 2 months or 3 months to accused to pay this money, and he won't do it. He did not do it, and you don't know, okay, will it he do in a second or third month or in half a year? You don't know, and you need to communicate with these persons, and sometimes it is really hard to communicate with them. And the other negative is that because this decision is final, it is a big danger for prosecutor that when he makes a mistake, and he will do this decision even when there are not fulfilled all the conditions, it is a big problem for him because this decision could not be revised in the second level, and that's the barrier, and he will be punished for the mistakes if there is really a mistake from his side. Okay, what about the plea bargaining? There is not many barriers, only confession and consent of the accused person. And there is also the positive that you don't need to pay the damage in this case. So it is more often used, this plea bargaining method. It's mostly used. But in this case, it is big administrative burden on prosecutor. The prosecutor really doesn't like this method because he needs to do 3 documents instead of 1. He needs to summon the accused and the victim because when he filed the indictment, it is only 1 document. He could do it immediately after the closing of investigation. But in this case, he needs to summon the persons. He needs to make these 3 documents. And there is very often the obstacle also that accused from bigger distance usually not appear to these proceedings because they say, we don't have money to come 100 kilometers and so on. And sometimes they come, but they don't agree with you on punishment. And then you made all these tries like for nothing, and you are really angry that you needed to spend the time for it, and there is no outcome, and you will even file the indictment as originally. So the prosecutors really better like to file the indictment directly and not to make this bargaining. Anyway, there is also not a good protection of remedies for victims in this case, and also you need to have the improvement of the court, and sometimes the court says, okay, this is not correct agreement, and you have problems again. And not effective when the punishments are too low, too low rates of punishment, because then you cannot offer the good conditions for the accused, and it's not valuable in these cases. Okay, this is the final slide of my presentation. The overall evaluation of these procedures. All these procedures really prolong the proceedings before the prosecutor. When he filed the indictment, he can do it like in 1, 2, 3 days. But when he makes these procedures, it is like months to finish the case and to go to the court. They have also more paperwork for him, because with the indictment, it is the one and last document that he makes. And with these ADR procedures, he makes more documents. And he cannot finish the case immediately. And when the accused or victims don't agree with these proceedings, then all his trials are void. So, and they are not suitable when the case is with more accused, because one agree, the second not agree, then you need to divide the case into 2 lines, and that's what really the prosecutors don't like. So what is the outcome? The outcome is that the Criminal Procedure Code has these provisions for these alternative dispute resolutions, but they are really used in practice very rarely because of these negative aspects of these procedures. So I'm open for your questions. You will read more about this topic in my written article. And if you have any questions, I'm looking forward for them. Thank you for your attention.
Well, Associated Professor, excuse me, there was okay, you can start, excuse me.
Okay, thank you very much. I try to start a presentation. Hello, everybody. My name is Olga Sobova. I am from the Czech Republic, and I would like to thank Professor Blažek because he spoke about the mandatory prosecution. And as we share the past and we share also the legal order, so I can make my presentation a little bit shorter. So you can see here the Czech Republic. I just would like to speak about a part of the paper and the Czech experience, because I think that we live in a new world, and the economic criminality in general and also the tasks of EPPO will change in few years, because we live in a globalized world. Now the digital world is not criminal by its nature, and it facilitates communication, enables to create new effective space, and enables also to ask cross boundaries without physical presence. It also makes an issue for the new types of cybercrime, or let's say digital crime. We would like to introduce the digital single market in the European Union, but we also have to create new approaches when the worldwide network is misused and used for criminality. What economic crimes in the Czech criminal code could be committed digitally? Of course, you can't commit digitally murder. of course, there are some attempts to make somebody to commit suicide, but generally the digital world is very good for economic crimes. Here I have listed some special economic crimes in the Czech criminal code, especially under the section taxes, fees, and foreign exchange criminal offenses. You can find the typical cross-border offenses as reduction of taxes and other similar mandatory payments, and also the failure to comply with reporting obligations in tax procedure. There are also criminal offenses against the mandatory rules of the market economy, like violation of regulations of rules of competitions or misuse of information in the trade, the so-called insider trading. All these crimes could be committed, first of all, digitally, because you have to apply and to give notice about the public procurement online in general. The information is now cloud computed, not only in a written form. So these economic crimes, like also crimes against intellectual property, or damage to the financial interests of the European Union, could be committed digitally from anywhere. So we have to invent new instruments for complying with the demands of prosecuting crimes in the cyberspace when they are economic. Just a few words about the prosecution, because we don't have the new criminal procedural code, which could be a contradictory procedure. We still have the mandatory prosecution and the tasks of the public prosecutors, which exercise the legality and supervise the legality of the pre-trial proceedings, and also enable to conclude out of court, or let's say divergence in the criminal proceedings, are similar to the Slovak Republic. So I don't want to repeat what you've already heard. And I would just like to draw your attention to the fact that in almost all EU countries, we don't have only the criminal responsibility of physical persons, but also of legal entities, which I find extremely important, especially for the cybercrime. Of course, we have the criminal responsibility of legal entities separated from that of their representative and other persons. We have a special law on criminal responsibility of legal entities, and the law does not expressly stipulate this special law for other divergences or, let's say, ADR procedure by legal entities, because according to this special law on criminal responsibility of legal entities, just stipulates for settlement about guilt and punishment. And moreover, especially by economic crimes committed by legal entities, the doctrine inclined to underline the difference between punishment and preventive measure. So what could be the divergence? Here I have listed the divergences stipulated for in the Czech criminal proceedings. I would like to underline that any divergence does not finish the criminal responsibility, and it always formed part of criminal proceedings, except for those offenses which are not criminal offenses, in fact, and they are sent into the administrative procedure according to Engel's criteria. Concerning the cybercrime, the main divergence used in the Czech Republic, but not only for the cybercrime, is the settlement about guilt and punishment, because this settlement in fact finishes the criminal proceeding, and as the criminal code provides for, there is a need for restitution of monetary damage in a form of agreement. But how to find a reasonable and justified divergence in digital economic crime, as it usually does not have a physical perpetrator? Tax, investment, and public procurement crimes are committed usually by representatives of legal entities or entrepreneurs. Juveniles commit in the Czech Republic crimes against intellectual property rights and payment instruments, and when it is a juvenile, a teenager so-called, then also the possibility of divergence is restricted, as their procedural rights are restricted due to their age, and so they must be represented by an attorney, and so on. But usually it is uneasy to find a physical perpetrator. In the Czech Republic, we have the experience that they usually appears when using the results of their crime. For example, money, or they appear as a part of public procurement, and so on. So at this moment, finding reasonable and justified divergences in economic crimes which were committed digitally, it's a question for discussion, not a question that is solved. Usually the damage is referred to the civil proceedings, unless the settlement about guilt and punishment is not concluded. So generally, if the perpetrator appears, if there is somebody is accused, either the physical person or legal entity, then usually in these types of crimes, the settlement is concluded. Just few concluding remarks. So the digitization is moving ahead quickly, also due to the pandemic. And also the situation we face, especially now in the Central Europe. We have again to underline the international or globalized dimension of the digital economic crimes, which need multidisciplinary approach, not only legal approach, but also the approach of commercial or criminal legal approach, but also the commercial legal approach, as well as the prevention in technologies. So that's what I would like to underline, that we have to move from our usual view on the offender or perpetrator as a physical person or legal entity, but known to the prosecution or to the victim. We have to move in this type of economic crime to someone who is not known. We have to we have to invent new technological barriers for prevention and new instruments for finding those perpetrators. And also, I think that there will be the need of new ADR or divergences in the criminal proceedings. Hopefully, our new criminal code, which is under preparation for almost 20 years, will find some solution. So there are some sources if somebody is interested, which will be also listed in my contribution. And I would like to thank you for your kind attention. Thank you and have a nice day.
Thank you, Olga, very much. I think now I'd like to thank the three online speakers. Please stay with us. If we have time, maybe there are questions for you. Thank you very much again. I hope to see you next time face to face. And I would like to pass to the speakers who are under this table. Now I have calculated you have 20 minutes, which means 10 minutes each, not more. Okay, you have organized it. Please introduce yourself. You pronounce your name surely better than me. I will only say that I am very happy that we have Belgrade, and I hope we will have your country in the European Union very soon.
We will see. We will try. Thank you very much. We are very honored and pleased to be here today with you. And we are very grateful to Professor Alessandra Lanciotti, who invited us to be a part of this very, very interesting and very important project. My name is Jelena Kostic. I'm Senior Research Fellow and Professor, and I'm working in Institute of Comparative Law in Belgrade, Republic of Serbia. Our topic is diversion of the criminal procedure versus adequate criminal policy in the field of financial crime in Serbia. And our focus is especially on criminal offenses regarded to the protection of financial interests of the European Union. Some of them could protect them, bearing in mind that we, for many years, use the funds from European Union funds. Another one speaker, she will introduce herself, is my dear colleague, Marina Matic-Bošković, Research Fellow in the Institute of Criminological and Sociological Research, and also lecturer at a few universities in Belgrade. So if you, now we can start, bearing in mind the short time for our presentations. The obligation to protect the European Union financial interests is also a requirement for the EU accession countries. But we think, our opinion is that's not only important for the accession process, it's also important from our national financial interests. By signing the Stabilization and Association Agreement from 2008, the Republic of Serbia became eligible to use various EU financial support programs. And that's the reason why we must have a strong enough criminal law protection of EU financial interests. The Serbian government undertook the obligation to take adequate measures at the national level to control and protect intended use of EU funds. And we did it, and we are still trying to improve that kind of protection. During 1993, the Copenhagen criteria, protection of the EU financial interests and obligation to harmonize national legislation with the acquis communautaire in this area is very important during the accession process, during the Copenhagen criteria. The notion of criminal protection of the financial interests of the European Union, as we all know, doesn't mean only the protection by provisions of substantive criminal law. It's also the protection by the procedural criminal law. You can hear more about it by a colleague of mine, Marina Matic-Bošković, and also the most important from the protection of the EU financial interests is preventive measures. preventive measures which should be done by the inspections, audit institutions, and of course, mechanisms of internal control inside the institution or in public sector. The protection should include all measures, as I mentioned, both criminal proceedings and other measures on the territory of member states, and in our case, in the member who are in the session process and who conduct proceedings against the perpetrators. According to the 2021 European Commission's report on Serbia's progress in the accession process, our country achieved a high degree of alignment with the acquis regarding the protection of EU financial interests. However, it's necessary to ensure the full compliance with the EU directive on combating fraud against the financial interests of the European Union in accordance with criminal law. Now we have enough criminal offenses, but later we must change some provisions, bearing in mind that we are still not members of European Union. It's a special, I think we must to change provision regarding the criminal offense tax evasion, and of course smuggling. According to our strategic plan for the fight against fraud and management of irregularities in the handling of EU funds in the Republic of Serbia for the period from 2021 to 2023, are identified problems with interinstitutional coordination and cooperation, which are caused by the following factors. You can see low of awareness of the obligation of reimbursed and incorrectly spent pre-accession assistance, risk management and assessment of internal control systems is very weakness, shortcomings in data collection and analytical tools, insufficient communication, insufficient exchange of information between the relevant institution, and shortcomings in the investigation procedures. Regarding this problem about institutional coordination and cooperation, the problem also exists when we speak about the national financial interest, and in the previous period you can read more in our paper. In the past period we tried to do something and to change something, but we will see how results it will be in practice. Also, we have the more weaknesses which are mentioned in this strategic framing, but bearing in mind the short time for this presentation, I won't mention all of them. The criminal legislation of the Republic of Serbia include criminal offenses that can provide protection to the financial interests of the European Union in terms of protection of its public revenues, tax offenses, and prescribed by a criminal code. And also we have tax offenses prescribed by tax legislation. I think it's not a good solution, and I hope later we will change it, because it's not good enough if you have some offenses prescribed by criminal code in same material and another one prescribed by substantive legislation. And also we have criminal offenses regarding the protection of the budget of European Union. I won't prescribe in detail these offenses. You can see which kind of offenses and which offenses are prescribed by our criminal code. You can read later in our paper, but some of them we must change in the future period when we become members of European Union. Now here you can see shortcomings of the legislative framework when it comes to the criminal offense of illegal obtaining of loans, subsidies, and other benefits who can protect the budget of the European Union that can be used to sanction illegal spending of the EU budget funds. We should prescribe stricter criminal sanctions and the statute of limitation in the national legislation for financial crimes, not only crimes regarding the protection of EU budget, is extremely short, and due to the complex procedure in detecting the existence of irregularities, it expires before initiation of criminal proceedings, and that could be the problem in prosecuting of this crime and also the crime regarding the EU financial interests. The mechanism for recovering funds is not efficient enough, especially when we talk about the local self-government level. Bearing in mind that we have a brief time for this presentation, now I will give the floor to my colleague Marina Matic-Boško. The floor is yours.
Good afternoon. My colleague briefly provide overview of substantive criminal law protection of financial interests, both of EU funds and Serbian budget. But when we discuss criminal procedural legislation and diversion of the criminal proceedings, we in Serbia introduced that almost 20 years ago with some amendments over the time. And according to the last amendments 10 years ago, main role in the diversion of criminal procedure has a prosecutor. So it's up to prosecutor to decide for all crimes up to 5 years of imprisonment if they go with the diversion of criminal procedure. That means that all crimes that are also relevant for protection of EU financial interests could be used in diversion, or diversion of the criminal procedure is applicable to them. What is important is that prosecutor is deciding about diversion, and there is no role of judge to confirm decision of the prosecutor. What is also important is the position of the prosecutor in Serbian judicial system, because according to the constitutional, prior to amendments from February 2022, which are still not applicable in practice since we are missing legislation. For its applicability, prosecutors, head of prosecutor offices are appointed by Parliament on the proposal of the government. It's strong hierarchical structure, and superior prosecutor can take a case from any lower prosecutor and give to another or decide on him or herself. So having in mind this kind of structure, and on the other side, really big or significant competencies of the prosecutor in diversion of criminal prosecution, it has influence on the public perception of its use in the practice. So there are a lot of media articles about diversion of criminal prosecution, and it's perceived as something that is used by privilege. It's a privilege of rich or some people who are connected to either government or elites in the country. Although it's very effective because it could be finished within several days or a month between a prosecutor and an offender, it requires consent of the offender related to the obligation, because prosecutor is the one who is proposing different obligation to the offender, and these obligation are ranging from fines or paying of money in humanitarian purposes to different kind of obligation of treatment. For us, are probably important the ones that are related to the payment of funds into the humanitarian purposes. However, this amount is not interlinked with the possible fraud or possible damage to the budget, either for Republic of Serbia or EU funds. It's usually very, let's say, symbolic in comparison to this type of crimes. It's approximately 400 euro, so it's really not in relation to the damage that could be caused. in almost 90% of cases, payment of money in humanitarian purposes is imposed. As I said, it influenced badly on the public perception of both deferred prosecution, but also justice system in Serbia. One of the limitations of the diversion of the criminal proceedings is the position of offender and in comparison to the position of injured party. In accordance with the latest amendments, we don't have any role of injured party in the decision of diversion of the criminal proceedings. Prior to this amendment, injured party or victim has to agree with that. Now there is no role for injured party. Also this remove any elements of restorative justice. There is no any transparency or publicity of these cases, except in a situation where some public public officials or some people that in which there is interest of public are involved. Otherwise, public is not aware how and who are the person on which the diversion is applicable. Offender and his lawyer are the one who could propose the deferred prosecution, in addition to the public prosecutor, who could also propose that in certain cases. It is important to mention that deferred prosecution is very widely used in Serbia. It's almost 15% of total number of criminal cases in which diversion is applicable. There is no comprehensive guideline for application of deferred prosecution. There are three different guidelines for specific cases, if it is possible to use it several times against the same person, or for which type of crime in situation when drugs involved, it cannot be applicable. But as I said, for this type of financial crimes, it is possible. Also, there is a lack of oversight mechanism. On the one side, there is no control of the judge, but also monitoring of implementation of obligation imposed to parties is also missing. There are legal provisions, but in the practice, we are missing bylaws or some rules, guidelines for its implementation. We don't have specific statistics to follow in how many cases deferred prosecution was used to criminal offenses for protection of EU financial interests, so we cannot share that data with you. When it comes to conclusions, you could already hear from the colleague that sanctions are very mild for this type of criminal offenses, so it should be stricter than probably on most of these crimes. Deferred prosecution would not be applicable. Then status of limitation should be prolonged. Currently, investigation for this type of crimes is very difficult, and it requires a lot of coordination and cooperation between different institutions to collect evidence. So it very often happen that it expires even during the investigation phase before indictment. Then recovery of funds should be, mechanism for recovery of funds should be improved, as well as both legislative amendments on the deferred prosecution, either to involve control of the judge or also involvement of the injured parties in consent for application of deferred prosecution. Also then some comprehensive guidelines for prosecutors how to apply deferred prosecution in the practice. And especially when it is related to the EU crimes against EU financial interests, to avoid any abuses or at least a negative perception in the public. Thank you.
Thank you very much indeed. Now we have 2 instead of 3 speakers. I understand well. Thank you very much. You start.
Okay, can I start this? Okay. Can we start? Okay. Hello, everyone. Now it's our turn to present our topic, and it's topic negotiated justice for crimes against the EU financial interest, the Croatian perspective. It was prepared by my colleagues, Professor Elizabeta Vičer-Karas, Associate Professor Zoran Buric, who is sitting here. He's also here, but he will not, because of the time, speak, and myself. The topic is also connected to the project that we have in Croatia, and is the project or systematic approach to models of negotiated justice in Croatian criminal procedure, the project of Croatian Science Foundation that we've been working on for a year and a half now. We would like to thank the organizers, the University of Perugia Department of Law, for inviting us to participate in this valuable project. Being the last in this session, we will try to keep everything short and simple, but you will be able to find more information in our written contribution. We would like to say something about the implementation of PIF crimes in Croatia, then on the conditional deferral or withdrawal of criminal prosecution in Croatia as the most important form of diversion in Croatian criminal procedure. Then we would also like to give a short overview of other consensual forms in Croatian criminal procedure and to give some final remarks at the end. Regarding the implementation of PIF crimes, maybe the most important thing is we have implemented these crimes by criminal code. And in regard to the work of EPPO, the crimes are implemented in criminal code, and the other provisions needed for the implementation of the European Public Prosecutor's Office in Croatia are in a special law on the implementation of EPPO regulation. Regarding the PIF crimes, we have three different crimes: so tax or customs duty evasion, subsidy fraud, and fraud in business operations. There are also very big critiques by the scholars that actually we did not implement everything as we should have done. So, for example, there is a critique that it's necessary to introduce a new offense of fraud in public procurement, which would criminalize the conduct referred to in Article 3B of the PIF directive. Regarding the tax or customs duty evasions, I will not give you all the elements. You will be able to read about that in a written contribution, but there is also critique that it does not cover the third modality of VAT fraud committed in cross-border fraudulent schemes. So there is again appeal to implement it as a part of the criminal code. Regarding the subsidy fraud, there are no critiques. And also regarding the Article 4 of the PIF directive, we have money laundering in Article 265, abuse of position and authority in Article 291 of the Criminal Code, taking a bribe in Article 293 of the Criminal Code, and giving a bribe in Article 294 of the Criminal Code. There is also a strong critique that actually we did not transpose or implemented the crime of misappropriation. And maybe to sum this up, there is many scholars think that we actually did not implement the PIF directive as we should have done. And I think actually it's the same problem with many of the EU countries. I think Commission is now checking everything, and we will know the results maybe in the near future. And this implementation is very important for the work of the EPPO, because it's a precondition of correct work of the EPPO. If the crimes are not put in the criminal code, the EPPO will not be able to work. Okay, in this part, now we'll go to the procedural issues, and my colleague Elizabeta Vičer-Karas will continue. Very well said.
Thank you, Marin, for leaving me a little bit more time than you had
Yes.
for your part of presentation. Hello, everybody from my part as well. Well, I will try to present a brief conditional deferral or withdrawal of criminal prosecution existing in Croatian criminal procedural law as Croatian model of diversion, which actually serves this particular goal or purpose of reaching restorative justice within criminal procedure. This Croatian model of diversion was introduced, first introduced with the new Criminal Procedure Act, enacted in 1997, and one of first consensual forms introduced in criminal law in general. And it was actually imported from juvenile criminal procedural law, where it worked quite well, which is logical if we have in mind that criminal procedure conducted not against, but maybe towards juvenile offenders serves this particular goal of education, rehabilitation, while general prevention and of course retribution is not in the focus. So the model worked well in juvenile law, and it was transplanted to a Criminal Procedure Act, and it is applied ever since with some modifications. This consensual form is based on the principle of discretionary prosecution, which is important to stress since in Croatian criminal procedural law, the principle of mandatory prosecution is dominant, which means that the state attorney must prosecute and may only desist from prosecution if in cases that must be explicitly prescribed in legislation. In this case, when the state attorney applies this principle of discretionary prosecution, of course, there are some very strict preconditions prescribed by law, but it is left to the state attorney to decide on the opportunity of prosecution or whether there are some other interests that actually prevail over interest of prosecution. This model can be applied only for criminal offenses punishable with a fine or imprisonment of up to 5 years, meaning that it is meant only for less serious criminal offenses, which narrows down the field of applications in start. Besides reaching the agreement between two parties, the prosecutor, the state attorney, and the defendant, this model implies mandatory consent from the victim, which is rather important to stress because involvement of the victim is an important element of this restorative justice concept. And the legislator insists on that, even though the research that we conducted recently through interviewing practitioners, state attorneys, and judges, showed that some state attorneys are reluctant to go into this model, of negotiations, because they find it difficult to negotiate not only with the defendants and suspects, but also with victims, which I mentioned particularly if we know that our colleagues from Serbia said that the victims were excluded from this model of consensual justice or consensual form. The suspect or the defendant, because this model may be applied at earlier stages of procedure, even before the formal criminal procedure started, all the way to the end, before the closure of a main hearing. But in practice, it is usually applied in earlier stages most usually applied at the earlier stages of procedure. It implies that the suspect or defendant agrees to assume one or more obligations, and the state attorney assumes the obligation to desist or withdraw from criminal prosecution in case the defendant fulfill his or her obligations. And these obligations may consist of repairment or compensation of the damage, or obligation to pay a certain contribution to a public institution or for humanitarian or charitable purposes, to pay alimony due to liabilities, to carry out community service work, to undergo treatment for drug addiction or other addiction, or a psychological treatment to treat violent behavior. And if you take a look at these measures, which are called also informal sanctions, we can notice that they are very similar to some safety or security measures that are applied with conviction. At one part, and on the other side, we see that this restorative purpose and involvement of victim is clearly visible in these obligations. And it is also important if we have in mind that this restorative purpose is the main purpose of this consensual form. And finally, very briefly, in conclusion, this conditional deferral or withdrawal, as I said, may be applied only for less serious criminal offenses to this specific purpose, and like all the other consensual forms that I will tell you in brief in a minute, it serves this specific purpose, restorative purpose, restorative justice, besides procedural economy, which is common purpose for all consensual forms. And I will also compare this form to some other concurring consensual forms a little bit later when I present them, very, very briefly. So all the other consensual forms may be divided in two groups. The first group includes consensual forms based on the principle of mandatory prosecution, and the second group may include those forms based on the principle of discretionary prosecution, as deferral is based on the conditional deferral is based on the principle of discretionary prosecution, while another systematization of consensual forms in Croatian criminal procedural law may be given depending on the gravity of criminal offenses, which may be object of particular consensual form, and particular purposes of each consensual form. So, again, in brief, consensual forms that are based on the principle of mandatory prosecution, and basically it means that they include conviction at the end of procedure, conviction before the court, are judgment based on agreement of the parties, which is a Croatian version or Croatian model of a classical pre-bargaining procedure, which means that the defendant will plead guilty before the court, will reach the agreement with the state prosecutor, with the state attorney. That agreement will have to have certain points. And then the court will bring the judgment of conviction. Of course, the defendant or the accused will be motivated to plea bargain with less severe, significantly less severe punishment that will be pronounced in the judgment. While, of course, the state attorney will be motivated with those classical motives that motivate state attorneys to plea bargain. Which should something that should be stressed is that this judgment based on agreement of the parties may be applied in case of all criminal offenses, even very serious criminal offenses. Though I should mention that internal instructions by the state attorney general contain instruction not to go into plea bargaining for the most serious criminal offenses, even though some researches that we conducted previously show that it was actually used in some cases of murders or attempt murders, rapes. So this means that it is applied even for serious criminal offenses. And another thing that should be pointed out is that in Croatian criminal procedural law in general, there's a strong judicial control. Of course, not only at the stage of trial, which is common, but also during the entire pre-trial procedure. And this judgment based on agreement with the parties is delivered before indictment panel, which means before the start of main hearing at the trial. And the legislator actually provided through legislation for significant powers of the court to control the agreement and to refuse the agreement in case the agreement would be unlawful, or if the agreement would not comply with the rules prescribed in criminal code, which concern measurement of punishment. But in the jurisprudence of the Supreme Court of the Republic of Croatia, those authorities were very much narrowed down. The Supreme Court said that this possibility to control the measurement of punishment, whether the punishment is appropriate and fair, were practically narrowed down to the extent that the court only controls whether the punishment is within the framework. The main reason was that the Supreme Court had given is that the court at the stage of indictment panel does not have enough information. The evidence has not been presented yet to evaluate all the circumstances that are usually evaluated at the end of the trial, at the end of the main hearing and after the presentation of evidence. So actually the role of the state attorney is very important, and he's the one who sets the criminal punishing policy in this case. Another consensual form is penal order, which is also intended for less serious criminal offenses, punishable with a fine or imprisonment up to 5 years. It is very often applied in practice. And the third form is judgment-based, rendered after conviction at the main hearing, also for less serious criminal offenses, saying that when the defendant confesses the guilt at the trial and agrees to a punishment proposed by the state attorney, then the court may not pronounce any other sort of punishment or more severe punishment, only less grave punishment. So penal order and judgment rendered after conviction are considered tacit agreement or silent agreements. There is no formal negotiation. They work on the principle that the state attorney makes an offer of the penalty or other measure, and it is on the defendant to accept that offer or not. But it is agreement because in case of penal order, the defendant may object if he or she does not agree, and then the regular proceedings continues. And in case of judgment rendered after conviction, the defendant does not have to agree with the punishment that was proposed by the state attorney. So it is a form of, I will break down. The consensual forms based on the principle, on discretionary prosecution, besides conditional deferral, we have crow witness and witness immunity, which serve typical purpose, that is obtaining witness testimony that will be used in another criminal procedure, which is obviously not a purpose typical for restorative justice. Although all these, both crown witness and witness immunity can be used for serious criminal offenses, even those who may fall within the if crimes, in case they are listed in a catalog contained in so I will briefly close down. I will skip the last slide. I would just like to compare the use of conditional deferral or withdrawal of criminal prosecution and penal order, the statistics. Conditional deferral of criminal prosecution is, according to recent statistics, used in approximately 1.6% of state attorneys' cases, while penal order is used in approximately 40% of all indictments filed before the court. Through our research that we conduct in a project that Marin mentioned, we tried to see why is that the case. The most important interviewees were state attorneys who gave different answers, but some of those answers said that the procedure of penal order is much more simple than deferral, because it requires from the state attorney simply to file the request for penal order with the indictment. While in case of deferral, which is meant for the same group of criminal offenses, the engagement of the state attorney in the case is much more significant, because he has to negotiate with the suspect, he has to negotiate with the victim, and that he has to control during certain period of time whether the suspect or defendant fulfills the resumed obligation. And in case he does not, he has to do everything from the start, indict, etc. So very practical reasons, according to some findings, go in favor of penal order and not this deferral, conditional deferral, which is, according to our opinion and according and from the perspective of restorative justice interests, very useful instrument. So the conclusion could be that there should be some kind of motivation, very concrete motivation through evaluation, additional evaluation of the state attorney's work, because they are evaluated at points for the cases that do, additional evaluation of cases where conditional deferral is applied by the state attorneys. Thank you very much.
Thank you very much. All speakers, they were able to, all their the contribution within the timetable of 1 hour and 20 minutes. The problem, we started with 20 minutes, 25 minutes delay. So my question to Professora, can we have time? Do we have still time for questions? Couple of questions? Bien. Alors, on y va. If you don't have a question, I have a question. Anka Arma, Anka Julma, sorry, is she there? No. She's gone. Okay, otherwise I will raise with you the question. You talk about sometime about the opportunity principle. The question is whether the opportunity principle is applicable in case of recovery money frauded, EU money frauded by national. Because first of all, there is an obligation for member states to recover the money frauded and to prosecute the person who has committed the fraud. Now, a public prosecutor cannot allow himself to say no for different reasons, because I have too much work, it's not my priority, it's not important not to prosecute, because in other countries where there is a legality principle will be prosecuted. So my and finally remark is that in the EPPO regulation, the principle obligatory legality of the action is foreseen. So there may be some contrast between the two obligations. Even before the regulation, I mean, in my opinion, the opportunity principle was not applicable when it comes to recover the money and punish the fraudsters. What is? Do you have any? Okay. Oh, thank you.
So in line with the Article 40 of EPPO regulation, it is actually possible to have some alternative forms of procedures, but then, of course, EDPs and also permanent chambers will have to decide whether it is okay or not to use this procedure, but they have guidelines, and in the guidelines they said that recovery is a very important element for deciding to use this procedure. So in a way, I think when there is no recovery, there is possibility that they will not use it as a resolution of the case. But there is theoretical possibility to use it.
Well, let's decide the equality of treatment of the operators in the member states. There's also a question which has to be considered. Any other question? Allez, un po' di dinamismo, fosforare. Yes, but I asked Madame. You are there. Do you have any observation about what we said about legality or the opportunity of the, legal action, opportunity principle? Anka was talking about the opportunity principle in the Romanian legislation. Well, she's not there. What this is one of the questions, of course, but no, I think that it is very important what you are there. Are you there, Anka? Yerma?
Yes, I am. Sorry, I missed.
Sorry to bother you, but you talked about opportunity principle, which is applicable in Romania. I was just saying that, in principle, first of all, the PPO regulation speaks about legality of the action, legality principle, governing the action of the PPO. And secondly, even before, my opinion, there is obligation not only to recover the money frauded, but also to punish, to prosecute, let's say, punish it depends on the judge, but there is a legal obligation for the public prosecutor to prosecute. He cannot judge whether, I mean, he has a margin of maneuver. He has, in my opinion, no margin maneuver. He has simply to prosecute, because community law is higher in hierarchy to national law.
Yeah. Well, as I said, in the Romanian law, we have this new principle introduced in 2014, but it has a very limited application, and it has to be related to the lack of public interest in the prosecution. And therefore, even the legislator put a very, for the Romanian legislation, not very high limit of the offense is applicable for the offenses punished with less than 7 years imprisonment. For instance, it could not be applied for passive corruption. But in practice, it is this opportunity principle is applied for the very de minimis criminal offenses. I mean, as I said, in our statistics, not more than 5% of cases are concluded with waiving of the exercise of the criminal action for lack of public interest. And as far as the EPO cases are concerned, I think that they would not have the occasion to use this procedure, because the competence of EPO starts above for offenses that created a damage of above 10,000 euros. And most surely that would be considered a threshold high enough for not applying this principle. So only the national prosecutors will apply it. And as the law specifies, among the obligations that the prosecutor will have to impose to the defendant for this procedure to apply is to repair the damage to the victim. So at least in terms of covering the civil damage, recovering the financial damage, that will be solved in any case.
If there are no other remarks, I will conclude here. I will thank you very much indeed, an online speaker and speaker in presence. The level of the contribution shows that the study has been taken very, very, very seriously, which is not always the case in my experience, but this one will be a really very important report, which can help the PPO, but all services commission, particularly of in, let's say, judging what the national and European public procedure are doing. Because now we will have a real picture of what happens in most of the member states and applicant countries. Well, Alessandra, Professor, at what time, because it's foreseen about 10:30. Ok. Vorrei ringraziare le studentesse che sono rimaste, anche se è una materia molto ostica, però questo vi dà un po' diciamo, un assaggio di quelle che sono le problematiche a livello dell'Unione Europea. Grazie particolarmente a voi. Thank you very much, everybody.
So good afternoon, everybody, and we are starting now the second session of this conference. And so my role here as chair will be limited to giving the floor to the speakers and to